hearing of the Legal and Constitutional Affairs Legislation Committee inquiry into the Administrative and Judicial Review Legislation Amendment Bill 2026. Just rolls off the tongue. I begin by acknowledging the traditional custodians of the lands on which we meet today and pay my respects to their elders past and present. I extend that respect to Aboriginal and Torres Strait Islander peoples joining us today. The committee's proceedings today will follow the program as circulated. These are public proceedings being broadcast live from Parliament House and via the web. I'm Senator Stewart. I'm joined today by Senator Blythe, Senator Cox, Senator Cash and Senator Shoebridge. I remind senators of their obligations under the Behaviour Code for Australian parliamentarians to treat witnesses with dignity, courtesy, fairness and respect. I remind witnesses that in giving evidence to the committee, they are protected by parliamentary privilege. It is unlawful for anyone to threaten or disadvantage a witness on account of evidence given to a committee, and such action may be treated by the Senate as a contempt. It is also a contempt to give false or misleading evidence to the committee. The committee prefers to give evidence in public, but under the Senate's resolutions, witnesses have the right to request to be heard in confidence, described as being in camera. If you're a witness today and intend to request to give evidence in camera, please bring this to the attention of the Secretariat as soon as possible. If a witness objects to answering a question, the witness should state the ground upon which the objection is taken, and the committee will determine whether it will insist on an answer, having regard to the ground on which it is claimed. If the committee determines to insist on an answer, a witness may request that the answer be given in camera. Such a request may, of course, be made also at any other time. A witness speaking for the first time should state their full name and the capacity in which they appear, and witnesses should speak clearly and into the microphones to assist Hansard to record proceedings. Mobile phones and other electronic devices should be switched off or turned to silent mode. For those appearing via video conference, please ensure your microphones are muted until you are called to speak. And also flagging, of course, there's the testing of the national emergency signal today at 2 p.m. as well, which we will not be able to silence. I now welcome via video conference representatives from the Andrew and Renata Calder Centre for International Refugee Law and Immigration Advice and Rights Centre. Thank you for taking the time to speak with the committee today. Information on parliamentary privilege and the protection of witnesses and evidence has been provided to you and is available from the Secretariat. Wondering if you would like to just begin by stating your name and the capacity in which you appear before going to an opening statement. Do you want to start with the Caldor Centre?
Sure, I'm happy to kick off. I'm Daniel Gizelbash. I'm a professor and the director of the Caldor Centre for International Refugee Law at UNSW Sydney. And I very much thank the committee for the opportunity to appear today. And given the focus of our work at the Caldor Centre on international and domestic refugee law and policy, my remarks today will focus in particular on the impacts of the bill on protection visa decision making.
Thank you. I'll just get the Immigration Advice and Rights to introduce themselves, and then I'll invite you both to make an opening statement.
Thank you, Senator. My name is Joshua Strutt. I am the CEO and Principal Solicitor at the Immigration Advice and Rights Centre.
Excellent. Thank you very much. I might go back to you, Mr. Gizelbash. Is that how I say your name?
Yes, thank you, Senator. And sorry, I jumped the gun there earlier.
Good.
So at the outset, I just want to reiterate the fact that the Caldor Centre supports the bill's objectives of improving the efficiency of the asylum system and also managing caseload surges and backlogs. Long delays are harmful for applicants and undermine public confidence in the integrity of Australia's asylum system. However, research suggests that many of the amendments proposed in this bill are unlikely to achieve those objectives. Indeed, they risk making the system both less fair and less efficient. The Caldor Centre has undertaken extensive research aimed at informing the design of fair and fast asylum procedures, drawing on both comparative analysis of asylum systems around the world, as well as data-driven research into over 40,000 Australian merits review and judicial review decisions. We've developed an evidence base of what actually drives efficiency across the asylum system. And the central finding from this work is that fairness is one of the principal drivers of efficiency. Ensuring applicants have a genuine opportunity to present their claims, supported by early access to high-quality legal assistance, is the most effective way of improving both the speed and accuracy of decision-making. Fair and effective procedures also ensure that Australia complies with its obligations under international law. This includes its non-refoulement obligations under the Refugee Convention and international human rights treaties, which require a system capable of reliably identifying those in need of protection, as well as the right to an effective remedy under the ICCPR, which requires genuine and practical, not merely formal access to review. To date, the government's attempt to address backlogs have generally focused on reducing procedural safeguards in the hope of increasing efficiency. Our research shows this approach has consistently failed. The reason is asylum procedures operate as an integrated system. Delays are not eliminated, they are displaced. If procedural fairness is reduced at one stage, the result is an increase in the volume of appeals and remittals, making the system as a whole slower, more costly, and less effective. Yet several provisions of this bill represent a continuation of that approach. We're particularly concerned about provisions that condition access to a written statement of reasons in the ART upon a written request by the applicant, the broad powers conferred on registrars to dismiss cases on the basis they have no reasonable prospects of success, and the proposed identity verification procedures. Not only do these amendments have significant adverse impacts on the ability of applicants to access review of their protection visa applications, but they're also likely to generate further litigation and appeals, shifting delays downstream to the Federal Circuit and Family Court rather than resolving them. Our submission, therefore, encourages the committee to consider a different approach. The committee has been provided with our policy brief, A Fair and Fast Asylum Process for Australia, which sets out recommendations drawing lessons from the Swiss asylum reforms, which reduced average processing times across their entire asylum system from almost 4 years to just 100 days. The recommendations center on 4 key elements: front-loading resources into fair and effective decision-making at the department level, using decision-making capacity most efficiently by streaming cases based on complexity, which would allow cases with low and high prospects of success to be resolved promptly in prioritized procedures with short procedural deadlines, coordinating procedures across the department, the Administrative Review Tribunal, and the Federal Circuit and Family Court, ensuring that prioritization of less complex cases is carried across the entire system. And finally, funding access to independent legal assistance throughout the process. A substantial body of research demonstrates that the legal assistance not only increases the fairness of procedures, but also leads to significant efficiency gains. It's also a non-negotiable prerequisite for applicants being able to navigate any shorter procedural deadlines that would operate in prioritized procedures. Finally, the Swiss experience also demonstrates that the process of reform matters. They were developed almost over a decade of consultation, piloting, consensus building, involving government, the refugee sector, legal service providers, and other stakeholders. Reform processes in Australia, by contrast, have too often been defined by rushed and piecemeal legislative changes with limited consultation and opportunity for scrutiny, as is unfortunately again the case with the present bill. Thank you very much for the opportunity to appear today, and I look forward to answering your questions.
Thank you very much. And Mr. Strutt?
Strutt, thanks, Senator.
Strutt, you've got an opening statement?
Yes, please, Senator. Thank you.
Please.
Thank you for the opportunity today to provide a submission at the inquiry into the Administrative and Judicial Review Legislation Amendment Bill. By way of background, the Immigration Advice and Rights Centre is the only free specialist legal service in Australia that advises on all areas of immigration, refugee and citizenship law. Relevantly, we have extensive experience providing advice and assistance to applicants at the former Administrative Appeals Tribunal, the current Administrative Review Tribunal, and at the Federal Circuit and Family Court of Australia. IARC's submission really focuses on the aspects of the bill that impact the migration system as a whole. IARC is very concerned that the bill places alleged deficiencies ahead of providing a system of review that is fair, just and accessible, disproportionately affecting vulnerable applicants. We are also concerned that the bill will not lead to greater efficiency, but instead lead to greater backlogs, especially at the judicial review stage. We do consider that greater efficiencies can be found through investment in free legal support. Providing free legal assistance to applicants and potential applicants will ensure that proper applications are lodged and that cases are properly articulated when they are before a decision maker. It will also discourage the lodging of unmeritorious applications through fair, frank, and expert advice, and break down the business models of unscrupulous agents who take advantage of vulnerable clients. We look forward to answering any questions that the committee may have today.
Thank you very much. We'll proceed to questions and begin with Senator Shoebridge.
Oh, thanks very much, Chair, and thanks to both witnesses and your organisations for not just your submissions here, but for your work throughout the year in this space. Could I just ask quickly, in the refugee caseload, in your experience, what proportion of applicants are unrepresented? And for that cohort, how would these changes impact? I'll go to the Caldor Centre first.
So I've got the data at the former AAT. I don't know. There's no reason to think that it's changed significantly since then. Although Josh may correct me, but in our AAT data set, 2/3 of applicants were unrepresented.
Cool. And yeah, is that your understanding?
We don't collect data really on how many unrepresented applicants. I can only speak probably anecdotally about the people who approach our service, but the majority of people who approach our service for assistance at the tribunal, we're generally unable to assist due to capacity restraints.
All right. And in terms of particularly those unrepresentative cohort, how would these changes, potentially having something dismissed by a registrar before even the first directions hearing, not getting written reasons, how would those changes impact on unrepresented applicants, sorry?
In our experience, we do come in contact with a lot of clients who have either lodged at the tribunal or have had directions hearings at the tribunal or have had a hearing at the tribunal and then approached our service for advice. Often there is quite a lot of confusion around what is occurring at the tribunal. Although measures have been taken to ensure that it is accessible and less formal than a court, there are still procedures, there are still guidelines that dictate the way in which the tribunal exists and proceeds. There are ART rules, there are the acts, there's migration acts. It's a very complex web of legislation that sort of guides migration matters at the tribunal. In our experience, a lot of people are quite confused about the process and what actually happens. We note in our submission that people who do not speak English as their primary language or English as a second language or don't speak English at all are often equipped with an interpreter or provided an interpreter, but they're by no means replacements for legal assistance. So understanding what has actually occurred at the tribunal, what the process, what affirmed means, what remitted means, those kinds of language is quite a complex process that people go through. They also don't often understand the legal tests associated in their hearing and what the matters in dispute actually are. And often people are approaching us too late, and we think that these changes will probably exacerbate those issues. So where people are forced... Sorry, go, Senator.
Yeah, well, can we drill down a bit into the proposed new power to allow registrars to dismiss cases where they think that there are, I think the test is no reasonable chance it will succeed. That's the test. First of all, that is dismissing matters is on a kind of merits assessment. That's novel work for registrars who are employees and not formally appointed tribunal matters. Is that right?
Yes, Senator. That was one of the concerns raised in our submission as well, that you have rigorous merits-based appointments at the tribunal for people to engage in merits-based assessments of applications through members and senior members. we understand registrars might not be put through the same processes or have the same qualifications and experience as members. So we are quite concerned that this may mean that registrars are being asked to participate in a merits review process without the appropriate training or qualifications. We also know that applicants also put forward, review applications without legal advice, as you're saying, a lot of unrepresented applicants, and they might not know what the facts and issue are, what to put in the review application in order to assist a decision maker to make that assessment as well.
And if they're going to be dismissed on the papers, they'll have put their application in without any assistance from an interpreter, often quite complicated questions. If it's going to be dismissed on the papers, they'll never have the chance to sort of articulate any of that with the assistance of an interpreter, which otherwise may well happen at a directions hearing where it becomes apparent what the issues are and they kind of crystallise the issues. But if they're going to be dismissed on the papers, that opportunity is gone. Is that a concern?
Yes, Senator, it's a serious concern for us in this bill. Yeah. Yes.
How about Cal-Law?
I think it's that comes through in a number of the submissions before the committee that generally people do not have access to legal assistance, particularly free legal service providers, until their hearing is scheduled, and that is when generally they have their first access to legal assistance and the first ability to get that assistance to articulate their claim. And the risk of this provision is rejecting applications which may have merit purely because of they haven't had access to legal representation as of yet.
And their initial application, they might feel there's something wrong in the decision that's been made, but because they're not lawyers, because English is not their first language, their application might be a mess, which if that's all you saw and you were a registrar, you might dismiss. And that's one of the dangers with this power, not allowing the application to come before and get to come before at least a directions hearing and get to that first stage where it can be kind of tested and understood. That seems to me a deep potential unfairness in this proposed legislation.
Precisely, and Senator, I'll add to that as well that the cases before the tribunal are very rarely decided just based on the information that's provided in the application. The process involves eliciting further information throughout the process from the applicant and denying them the opportunity to do that at this first screening stage would lead to unfairness and people with genuine claims or entitlements to a visa being denied access.
And not just in the immigration space, but across government, there's this great disparity of sort of power and information between an individual and these big government departments. And if this is a sort of, potentially broader power to dismiss matters, I mean, that just gets rid of the benefits of the ART, which is meant to force the agencies and government departments to actually come to the table and provide some information and be a good faith participant. That won't even start because the matter will be cut off at the knees, won't it?
Yes, that's correct. So you also touched on, I guess, a related concern here is just how broad and ill-defined these powers are. I mean, there's some intent expressed in the explanatory memorandum that so it's expected that this power would be exercised by registrars when an application has no reasonable prospect of success based on clear objective criteria, such that the application is bound to fail. But there's absolutely nothing in the actual provisions that would restrict that power in being used in that way. And circling back to the earlier point about the lack of a merits-based appointment process, the work we've done at the Caldor Data Lab shows that even with members who've been well trained, there's a significantly high level of variability in their decision making and inconsistency in decision making. I think the concern here is you give these incredibly broad powers to registrars, and it's actually going to lead to a lot of arbitrary decision making and significant discrepancies in the way different registrars might exercise these very broad and ill-defined powers.
And then if that's challenged, does that require an appeal up to does it go to the panel? The appeal panel, or do you have to take it to the federal court? Is this like another feast of litigation to the federal court when those matters are challenged?
So the best of my understanding is it goes back to the the applicant can reapply to the tribunal for the application to be reinstated. And I understand that's the registrar, again, that's responsible for making that determination. And then if that's unsuccessful, then it's appealed to the Federal Circuit and Family Court. And it is going to lead to, and this is one of the concerns we put forward in our submission, it will lead to a significant increase in the volume of litigation at the Federal Circuit and Family Court. And there are precedents, and as including cases cited in the Law Council submission that show that the court has in the past intervened to overturn decisions made by members using similar powers.
Yeah, courts don't like cases being cut off before anyone's even heard. And this looks like a feast of litigation and yet more delays in the federal court system. But could I ask you just quickly about, just to articulate a little more on two other aspects of it. One is the proposal to not give written reasons and to only give them on request. Again, when you've got, particularly say in refugee matters, incredibly tight time frames to challenge and deal with these matters, what impact will that have? I might go to Mr. Strutt first.
As I sort of foreshadowed earlier, I think a lot of the people we speak to either are pre-hearing or sometimes even post-hearing. And I think our concern really is a lot of the people seeking assistance from us who are unrepresented and often don't speak English and have had the assistance of an interpreter unaware of what's actually occurred. So they won't be aware of what the decision actually was. If it was given orally, they won't be aware that they can request written reasons within 14 days. And by the time they come to us, it might be too late to request that information. We are quite concerned. We even are concerned outside of the protection visa space as well. We assist women experiencing domestic and family violence who are appealing, refusals of partner visa decisions and are relying on the family violence provisions. So I think it's even broader than just the protection visa space. I think it has wide-ranging ramifications.
I will go to the Calder Centre in a second, but I might just ask to respond to both that first question and the second point. One of the other reasons why written decisions can actually be really important for a system is that they require a certain rigour and integrity to put it down in writing, to think about it, to articulate it. It actually is one of the ways you get some integrity and rigour in the system, particularly in a sort of quasi-judicial, administrative review matter. Do you have concerns that, if there's going to be all these oral decisions, that's actually going to reduce some of that rigour and integrity in the system, or at least potentially?
Yes, we are concerned, Senator. It's a big ask to us, a decision maker, to have to sit there, listen to proceedings and hearing and evidence, and then be asked to provide an oral decision as well, and to be able to consider all the evidence or the facts in issue and everything that's been put forward. We are concerned this will also degrade the quality of decision making and the kinds of robust decisions that you often get when people are required to provide written reasons for their decisions and think through the information and evidence that's been provided.
Now, there's nothing wrong in giving an oral decision, like having at the end of the hearing, having said, well, actually, I've heard it, for timeliness and because matters are in my mind, I'm going to give my reasons now and, give the oral reasons. But up to now, that's required to then be followed up by written reasons being provided. And it's that follow-up that's been removed, isn't it? And that seems to me to be, for the reasons you've given, a systemic problem. But there's nothing like giving oral reasons at the end of a hearing is actually really efficient and timely justice. But it should come with the backup of them being delivered in a written form so that applicants can see and challenge them.
Yes, Senator. I think as well, based on my over 10 years experience of appearing at tribunals as well, it's very rare that you see oral decisions, to be completely honest. It happens in very rarely in a few matters, but it seems to be this movement around encouraging people to give oral decisions. I think protection visa matters in particular and domestic and family violence matters are quite complicated and involve quite complex evidence and facts to be assessed. And so we are concerned that it would be very difficult to, not by no means are these requirements being imposed on people, but for us, it feels like there's a shift towards wanting decision makers to make decisions orally, or at least, that movement in that direction. And we are concerned about the flow-on consequences from that in quite complicated caseloads as well.
Well, I mean, I worked in the family court as one of my first jobs in the law and for a judge. And he would, when possible, deliver extempore decisions when the matters were kind of, was quite clear what the result, what he intended the result to be. And it can actually have a benefit in the moment, but it was always followed up by those being delivered in a comprehensive written format afterwards, which, ensured the integrity in the system. But could I just ask quickly about the, I might ask Caldo. Could I ask Caldo just to respond to that issue about written decisions, particularly in terms of timeliness? And then I've just got one other matter, Chair, with indulgence on identity, and then I'll stop.
Thank you, Senator. Yeah, I mean, I reiterate the points that Josh made on this in terms of unfairness. I think it's unreasonable to expect applicants to be able to understand and process oral decisions that are given, but particularly to understand their right to request written reasons. And there's nothing in the bill that requires or sets out how the tribunal will inform the applicant of the ability to access those reasons. And then there's concerns around the interaction with the time limits for lodging judicial review. If you've got 14 days to apply for decisions, for written reasons, 14 days for the tribunal to come back to you, that's most of the 35-day limit to apply for judicial review. The result will be people lodging judicial review applications at Federal Circuit and Family Court without even having seen the reasons at all, which is going to increase significantly the burden on the courts. And it's the same pattern I mentioned in my opening statement and submission. It's completely displacing that issue downstream. But I think from the efficiency perspective, my biggest concern is just to reiterate the point that it is very, very, very difficult for a member to be able to give an oral decision in the very complex migration system, particularly the procedural code and requirements, arcane requirements in terms of requirements that have to be met in that regard, and to consider all the relevant facts and not make a jurisdictional error when they're giving a decision orally. So I think there's two possible outcomes here. One is that members reflect, write down detailed written reasons, and then present them orally, in which case there's no efficiency gain whatsoever, and there's just barriers then on the applicant from being able to access those decisions. Or the other is less considered oral decisions being delivered that will be subject to successful judicial review and remittal, and again leading to systemic delays.
And there's been a pattern here now over the last 2 years. Home Affairs, particularly in the migration and immigration space, moving decisions out of their department, hastily making decisions, rapidly moving on for the cohort. They've then shoved that into the ART. That's now created a whole lot of problems in the ART when they're dealing with a whole lot of hastily made decisions without proper access to documentation by the department. Now that's overloading the ART, and now the government's proposing to move that backlog into the federal court system. It's a bit like the cat in the hat, the splodge just keeps getting moved through the system, isn't it?
Yeah, I think that underscores, I guess, one of our primary recommendations, which is actually the best way to address backlogs across the system is to invest in effective decision-making at first instance and ensure people have support and ability to properly put forward their case at first instance.
The document, the identification verification and the mandatory dismissal unless the documents are not provided to verify. I mean, I can't work out how it's going to work based on this legislation. I don't know what documents are going to be required. I don't know what protections there'll be for people. Can either of you, what do you see with this proposal?
It's just another barrier for people to overcome when trying to access review of their decisions. So we talk to people not only from countries where they, be unsafe for them to request identity documents and they don't have identity documents and it actually forms part of their protection claims, to also people where questions around their identity might also be central to their claims for protection or as well. We also speak to particularly women in violent relationships who their husband or their partner might be withholding identity documents. And we also have spoken to workers across Australia who have their passports withheld by their employer as part of the exploitation they experience. I think this reform only targets the most vulnerable applicants approaching the review processes in relation to their visa system, and does little more than that for us at the moment. We are quite concerned that it will just disadvantage these parties and mean that they fall out of the system and aren't provided with the procedural fairness and the review that they should be entitled to.
Leading to the dismissal of cases for the most vulnerable people who most need protection. That's where it's really going to hit the road. The Caldor Centre?
Yeah, I'll just concur with those comments. And I think that mandatory dismissal is such a blunt response and has really serious consequences for applicants, particularly in the protection visa context. The fact that these powers are so ill-defined that we have no details in the bill about which types of applicants will be targeted by these provisions, what sort of identity, what the process will be, what sort of identity documents will be required, creates a risk that it could be used in a really restrictive way to prevent people from being able to access review of their decisions at all in the first place.
And because it's mandatory, a woman, for example, saying, my violent and controlling partner who's stolen all my documents, I can't approach them, I would live in fear. That's why I can't give you the documents. Because it's a mandatory dismissal, doesn't matter. Potentially their case is just dismissed. That's, not only is it bad design, but it's compounded by making it mandatory dismissal, isn't it?
Thank you, Senator Shoebridge.
Just for the record, both witnesses nodded their heads.
Yes.
Thank you for that. Senator Cox.
Thank you very much, Chair, and thank you both for joining us to provide evidence this morning. I just wanted to pick up the point that Senator Shoebridge was talking about, which was the proposal for decisions in certain circumstances or certain matters to be delivered orally. What I did here was Senator Shoebridge offer a solution to that, but not actually the witnesses, around some of the potential safeguards to address some of the concerns that you have. Are you able to walk the committee through those? Maybe start with the Caldor Senator.
Thank you. Look, specifically, I don't think it's appropriate with any safeguards in the protection visa context specifically, which is the one I'm most familiar with. So any safeguards I suggest to you, I guess, as a backup if that position is not ultimately adopted. I think one of the issues is what I noted earlier, just about ensuring that applicants understand their right to access written reasons, and actually requiring a member to confirm that they have formed a view that the applicant does in fact understand that, and has to be happening in the hearing where there's an interpreter. Relying on documents sent in English, it's important to do that afterwards as well, but you can't rely on that in the hearing while in the presence of the interpreter. Having that duty that the member is satisfied that they understand that right would be one safeguard to consider.
Okay, thank you. I don't know if Mr. Strout has any comments he'd like to provide.
Thanks, Senator. I think the only comment I would add to that is, I think the only way in which delivering a decision orally would be okay is if it's a remittance. So if it's in the applicant's favour, then there is no requirement for the applicant to understand that decision for the sake of judicial review. My only hesitancy in suggesting this is it could also lead to frustration at the department stage. So if it is remitted back and there is a direction by the tribunal that the applicant satisfies certain criteria for the grant of a visa or something else, it would need to be communicated to the department to ensure that that visa decision can then be processed, quickly. But outside of that, I can't see a system based on the people that we advise where we would be comfortable with oral decisions and with the I guess restrictions on accessing written decisions as well.
Okay, thank you. I just want to note that during or in your submission, Mr. Strutt particularly, you make reference to some unscrupulous agents who provided false information to the tribunal in the review of migration matters. Can you explain to the committee what that experience looks like, and maybe give us some examples or particular examples that come to mind, just to articulate what that looks like?
Yes, thanks, Senator. Anecdotally, in our experience, I've spent the better part of the last year traveling around Australia providing advice to people in various situations, particularly people facing workplace exploitation who are on temporary visas. What we often see in the communities more generally is that people have not been treated very well by their employer, or the employer makes false promises around future visa sponsorship or something else, or the ability to remain here longer term. What often happens is that people are then guided to contact certain people who may or may not be agents, and by that I mean registered migration agents. Sometimes they are, sometimes they're not. I don't know either way. Who often help people lodge applications en masse to extend their stay or things, and they often take tens of thousands of dollars from people, charge them exorbitant fees which are nowhere near the VAC, promise them the world when they can't deliver, and these kinds of things. What we have found is that by us getting out into these areas and talking to people before that happens, it actually breaks down those business models, so people get access to fair, frank, and credible advice about what they're actually doing and what the long-term impacts may be around that. But what we are often seeing is that people are being taken advantage of in vulnerable situations, promised visa applications or to be lodged visa applications that they may or may not be lodging. I think the flip side to that as well is that often people are getting lost in this system as well. And so that people are often being caught up lodging visa applications when they actually should be lodging those visa applications, but they're being incorrectly lodged. So the agents aren't actually putting the right information, not seeking instructions, not doing the right thing. So it's a business model that exists out there that we're very much aware of, and that we're trying to, I guess, counter through the provision of free legal assistance and advice to these people before they get caught in this system.
Okay, I don't know if there are any other comments, but on this one, from the Council, Senator.
Yes, thank you, Senator. I think, I think this. I mean, it's a real issue, but I don't think the provisions of the bill are the best way to address them. And particularly, I know the identity verification requirements are trying to justify it in relation to this point. Firstly, it's also important to know the vast majority of migration agents are very diligent and do their jobs very, very well. It's a very small minority, and in particular of unregistered agents who are acting in this way. And the way to deal with it is through increased enforcement, rather than punishing what are essentially the victims of these agents. That combined with access to government-funded free legal representation, which would disincentivize the need for applicants to go to these agents in the first place. But more than anything, the misuse of particularly our protection visa system stems from the fact that there's such extended delays at a systemic level, and that is why a fair and fast process is so important there. If you can reduce the wait times across the system, from now it goes up until 10 years for some applicants, down to 12 months, then that incentive for putting in unmeritorious applications or unscrupulous agents recommending that people lodge unmeritorious applications or tricking them into lodging unmeritorious applications will be taken away.
Okay. I just wanted to clarify one point that you've made. And I mean, you know, we're seeing this across the service systems, not just in migration. We're seeing it at NDIS, and there are dodgy agents, right? Like I think it's the government's role to go after them, and you know, I don't necessarily disagree. And obviously this committee considers that on its merits and proposal for how we tackle that. I suppose my question really, and I just to clear that up, is: are there sufficient safeguards that currently exist within the system? And I'm just noting your point around, you know, it's not all agents. I agree with that, but you know, my understanding that if a matter is dismissed for failing to sort of meet the identity verification changes, that if it fails to meet that, an individual could seek a reinstatement and make their case as to why they don't have certain documents with them. Is that correct? And are they some of the safeguards that we're talking about, or are there others that are needed?
I think from IARC's opinion point of view, I think for us the concern is you're punishing the wrong people. You're punishing the applicants for this, and so what you're saying is someone could lodge something unbeknownst to you without any oversight, and then you could receive a dismissal because you didn't provide identity documents. And that person might be none the wiser. The applicant might not know because they haven't been provided with access to any of these things, any of these decisions, any documents whatsoever. And by the time they do find out, because they've accessed a service like ours, it's too late. The time period's expired or whatever else has happened. They can't get it reinstated. They don't understand what a reinstatement is. We don't think that the bill goes about dealing with these issues in the right way. We think, as Daniel has said from the Caldor Centre, you know, the idea of getting before a visa application is even lodged in the primary instance, giving people to free legal assistance and breaking down these business models by ensuring that people have access to a credible source that is affordable is the way to really drive change to ensure that these business models can't continue to survive and thrive. And we have seen it. We were funded to provide assistance to protection visa applicants at the tribunal and at the Federal Circuit Court, and we advised many people that their applications were unmeritorious and that they should withdraw. We told people when they had other visa applications, and we had an 87% success rate at the tribunal and the Federal Circuit Court when we did get involved. And so I really think that the bill probably won't drive the change. It will just force people who are already in very vulnerable situations into even more vulnerable situations as well.
Thank you for clarifying that. That's all from me, Chair. Sorry, I think Mr. Was there another comment? Sorry, I thought I heard something.
Thank you. So just very quickly, just directly answering your question about safeguards. It's very difficult to hypothesize about what sort of safeguards would be required for these provisions to be implemented in a fair and effective manner, just because they're expressed in such incredibly broad terms. It's unclear, you know, as I said earlier, about how they're going to be used, who they're going to target, what identity documents will need to be provided, and what safeguards will be provided. And without that information, it's very difficult to answer your question directly.
Thank you. Thanks, Chair.
Thank you, Senator Cox. Senator Blythe.
Thank you very much, Chair. And I just have a couple of questions which will sort of go along the lines of what Senator Cox was asking, and I might just pick up sort of where she left off in terms of looking at, you've spoken about some agents that are not behaving, I guess, in a necessarily scrupulous way. What percentage, so you said a very small number, what percentage do you think, if we're talking a small number, are not behaving in the right way? What's that number that you think it is?
I'm not sure I'd have the data on that, Senator, to be honest. I agree with Mr. Gezelbash's comments that it is a very small number. It's definitely not a lot of them. I deal with migration agents and lawyers in the profession dealing in immigration matters all the time, and for the most part, they're all very they're above board. They're giving full frank advice as well. It is a very small percentage, but we do see it enough that it is an issue that we do have to deal with from time to time. I think from our submission, we said 1 in 5 of the clients that we speak to have experienced migration fraud or failure in the last financial year. But that doesn't mean that that's all the it might be just the same migration agents or agents who are unscrupulous advising these people. I don't have the data directly on that.
Okay.
Senator. Yeah.
And that's sort of what I'm trying to sort of dig into is if it's 1 in 5, we could have some quite large. So rather than saying it's a large number of migration agents, it could be a small number, but are dealing with quite a large volume of clients.
Yes, that's possible, Senator. And it's also the people who come to our service as well, Senator. They are the people who are the most vulnerable. So it also depends on that demographic data as well. That's probably why it becomes most apparent, because the people who are being targeted are the people who are also the most vulnerable, because they've experienced some other hardships or vulnerabilities as well.
Yeah. I guess in terms of looking, and you've said, Mr. Strutt, that you support the intent behind Part 12, but you're opposing the measure because it is then punishing the applicant as opposed to the agent who has exploited them. I guess what other provision could be aimed at people who are taking advantage of those who are most vulnerable, other than, and you've mentioned that the digital verification requirements, you'd need more information to be able to figure out whether that works or not. What other things, in your view, may work?
One thing we did entertain and possibly didn't make it into our submission at the time, but was something about an active requirement to actually contact applicants directly, not even just through their representative, or at least have them also equally contacted. So the need for that to be done as well. I think my only issue, or one of my issues with that and what we have seen is people often do, people can create an email account without too much difficulty and pretend it's the applicant. So I'm not sure how far that would actually go to actually dealing with this issue, but some sort of positive obligation to actually deal with the applicant and their representative, or at least ensure that both the applicant and the representative are both aware of that the lodgement and the situation and the proceedings would go some way. I'm just not sure practically how you would implement something like that, Senator, is probably why it didn't make it into our submission, because I just don't see how that would actually work. And also it would probably cause a lot more work for the tribunal to ensure that they're actually dealing with the applicant and the representative. And the work that would go into that as well could be quite extensive in terms of just admin time and things along those lines. So I'm not sure if you would find the efficiencies you're after through such a proposal, but it would be something that would be maybe worthwhile exploring or further having a look into.
Yeah, thank you. I guess in terms of the backlog program, you've spoken. You've said that 67% of your clients had low to no prospects at the tribunal, and 57% that had no visa options and should consider departing Australia. Is your evidence to this committee that funded independent advice removes the more unmeritorious matters from the system, and maybe even more so than what mandatory dismissal would?
Yes, Senator, we do consider that when we do provide advice and we get in front of the issue and we can talk to people directly and give them full, frank and credible and free advice, that is a way that we can deal with the backlog. As the only service that actually advises on the entire visa system, so we're aware of all the visa subclasses and options that are available to them. people do come to us for that, I guess, that final advice or those final options, and we can give them that certainty. And that can either be, yes, there's merits here, you should continue, but it can also be the alternative where it's like, actually, this is not an option for you. You don't have any options. This is your only option. And we have found both approaches work in terms of we have supported people withdraw applications where they are unmeritorious and assist them with departure arrangements, or even assist them with other visa options as well. So we do think that this is something that could assist. To the Caldor Centre's point, we think also earlier intervention is also warranted. So to stop the backlog in the first place, you need to ensure that people, before even lodging a visa application, are told about their visa options, all the options out there. There might be there might be protection visas, but there might also be family visa options or skilled visa options or student visa options, just to name a few. But they need that sort of fulsome, holistic immigration advice to ensure that they know either definitively what their options are or what their options are not. And so they can make decisions based on those on that information, which also would have longer term consequences of reducing the backlog in the future.
Yeah, excellent. And I guess sort of going back to you've mentioned a little bit about a duty solicitor model as well. So in terms of sort of looking at that backlog, but also the no reasonable prospects, and being able to assist with the pipeline that we've got. Is that where the duty solicitor model would come in and potentially fix some of that as well? So working in tandem?
Yes, Senator. So we understand there are, equivalent programs in courts, and I appreciate merits review is different to judicial review in terms of how it operates and the tests involved and all of that. But we do really consider that having access to a service immediately for applicants and for members who, if they are presiding over a hearing and think that a person might benefit from free legal assistance, knowing that advice is readily available to them could be really, really good for applicants. For a lot of cases, we can have a primary or a preliminary view and a preliminary look, and it might be something that we could assist with on the spot. And for ones where we see that there might be some merit for more longer term legal assistance, where there might be some merits or something that needs to be investigated further, they could obviously be sort of referred back to the duty solicitor's services to just further make out the claims or the case or to do some further investigation. And we just think, in our experience, the ability for legal assistance service providers to put appropriate evidence and submissions before the tribunal just makes the decision maker's job a lot easier, makes them get to fair and reasonable decisions more quickly, and just makes the whole system more efficient overall.
Thank you. And I guess going into that 1 in 5 number in terms of your clients, are you able to provide that to the committee? So you said, it's difficult to sort of get that data, but I guess it's important for us to be able to see the scale of the problem. So it's not necessarily that it's 1 in 5 agents that are acting in a way that it is not as the system intended. But if it's 1 in 5 clients, that starts painting a sort of quite different picture. I guess, is this something for the mandatory dismissal mechanism? So is that something that can assist with that, or is this just a group of people who are being taken advantage of? And Professor, I'd be really interested in your views on this as well.
I think it's really just a cohort of vulnerable clients who are being taken advantage of, in our experience. So I'm not sure this would assist with the mandatory dismissal by any means.
Okay.
I think our point really is just that there are people out there who do take advantage, and it is by no means 1 in 5 migration agents or people purporting to be agents at all. the number would be much, much smaller than that. But it is people who, as part of their business model, prey on the vulnerabilities of people, and the desperation or hope that people might have, and use the existing systems and processes to do that. So that's where our concern really is that you've got these people who are being preyed upon, and we think they will just ultimately be the ones who are punished as a result, whereas the underlying problem isn't being dealt with.
Yeah.
Thank you, Senator. If I could make two quick points on this. I mean, the first is that I think the onus is really on the government and the department in particular to provide evidence of the scale of the issue, to justify these mandatory dismissals with really serious implications. There's no evidence provided in the explanatory memorandum, or that I'm aware of, that sets out the full scale of this issue. But in terms of solutions to addressing the problem, I'm going to refer back again to the policy brief that I've shared with the committee. I mean, if those recommendations are implemented, there will be no role for unscrupulous agents to play in the process, because people would have access to early legal advice from government-funded legal representatives. And also there would be a much faster system overall, taking away the incentive to make unmeritorious applications in the first place.
Thank you very much for that, Chair. That was my questioning. Thank you.
Excellent. Thank you very much. That concludes the questions that the committee has for you this morning. We've just ticked over to this afternoon, but appreciate the time you've taken out of your day to come and give evidence to the committee. You go with our thanks. Thank you very much. I understand our next witnesses are online, so I'll move directly to them. I now welcome via video conference representatives from National Legal Aid. Thank you very much for taking the time to speak with the committee today. Information on parliamentary privilege and the protection of witnesses and evidence has been provided to you and is available from the Secretariat. We might begin just with a hand-card record, if we can get you to state your full name and the capacity in which you appear before we move to opening statements. Do we have people from Legal Aid on? I can see an Yvette.
Hello, how are you?
Hi, how are you going? Who is joining you this afternoon? Is it Robin who's also joining you?
From Legal Aid?
Yeah.
Not that I'm aware of, no.
Yeah, okay. Is it just you who's with us today?
Yes.
Excellent. All right. Well, I might get you to introduce yourself and state the capacity in which you appear, and then you're very welcome to flow on into an opening statement.
Wonderful, thank you. Yvette Darth, I'm just checking my sound's working properly for you.
Yeah, perfect. Thank you.
Great. Yvette Darth, Executive Director of National Legal Aid. Thank you for the opportunity to appear before the Legal and Constitutional Affairs Legislation Committee today. National Legal Aid represents the 8 independent legal aids .
You've just gone on mute for some reason. I'm not sure why that's happened.
Okay, how's that?
You're mid-sentence. Sorry, you're very welcome to restart.
Okay. National Legal Aid represents the 8 independent legal aids in each state and territory of Australia. We work collaboratively to deliver essential legal services, focusing on areas such as family law, criminal law, and civil law. Our mission is to uphold the rule of law and protect the right of individuals, especially the vulnerable and disadvantaged. Legal aids provide legal advice and representation to clients with matters before the Administrative Review Tribunal and Federal Circuit and Family Court of Australia. This includes Social Security and NDIS matters and child support and permanent protection visa matters. Unfortunately, time-limited funding ceased for the Legal Assistance Permanent Protection Visa Program in 2025 and our ability to provide legal assistance in migration matters has been greatly reduced. We recognise the challenges in establishing the tribunal and backlog in migration and NDIS matters. We've engaged with the tribunal and government in working towards the principles of the tribunal as an independent mechanism of review. This is fair and just, accessible, and improves the transparency and quality of government decision making. NLA is supportive of the intent of the bill being to improve the efficiency and responsiveness of the migration review framework, supporting both Federal Circuit and Family Court of Australia and the Administrative Review Tribunal to manage their substantive migration caseload. Acknowledging also that the amendments would also amend the Administrative Review Tribunal's framework more broadly to enhance efficiency in tribunal operations. I note the explanatory memorandum outlining that the measures in the bill would be directed at streamlining processes, minimising administrative burden, and supporting timely decision-making in the tribunal. These are worthwhile objectives. However, they need to be balanced against procedural fairness and access to justice principles. This is, of course, needs even more care in ensuring the alignment with these principles when the individuals seeking recourse through the art and the court are from culturally and linguistically diverse backgrounds. In this context, National Legal Aid would like to outline two major concerns with the current bill. Part 1, Schedule 1 of the bill, expansion of registrar powers. We are concerned about the expansion of the registrar's powers, particularly the powers to assess whether an application has a reasonable prospect for success. Assessing whether an application has reasonable prospects of success is not a simple assessment of whether the application was made properly or whether the tribunal has jurisdiction to hear the matter. It requires a high degree of discretion and judgment with significant implications for the right to administrative review, particularly for disadvantaged and vulnerable applicants. Applications made by vulnerable, often self-represented litigants in these circumstances can often appear to be of poor quality or otherwise misconceived, and it is only when applicants access legal assistance or a hearing is conducted that the true merit of the application is able to be explored. Second point is Part 10, Schedule 1 of the bill, Notices of Decisions and Reasons. Part 10 of Schedule 1 of the bill would make a number of amendments to both the Art Act and Migration Act to permit the tribunal to give oral decisions in certain kinds of review and to provide that a written statement of reasons would only need to be provided if requested by a party to the review. Our concerns are focused on the implication of this to the migration and protection visa jurisdiction. NLA is concerned about access to justice and transparency of decision making. Written reasons are essential for applicants to understand why a decision was made, seek legal advice, and determine whether there are grounds to pursue further review. The bill proposes that the 35-day time limit to apply for judicial review to the court under Section 477, subsection 3 of the Migration Act would commence upon notification of the oral decision and not the issue of written reasons if requested. Written reasons may be requested within 14 days of the oral decision, and once requested, must be issued within 14 days for migration decisions. This amounts to almost the entire 35-day period for preparing and filing a judicial review application to the court. NLA would like to work with the tribunal and government to reduce the backlog in matters. However, the system needs to be considered holistically without prevention of access to justice. We've seen an increase in review applications to the tribunal because of the Department of Home Affairs making quick decisions on the papers without providing applicants with the opportunity of an interview. If applicants are not provided an opportunity to properly process, this in turn may increase applications for judicial review in the court, extending the length of matters in the legal system. National Legal Aid believes that we can create an efficient tribunal without eroding transparency and rights to fair access of administrative appeal. Legal assistance is fundamental to a functioning, efficient legal system through providing early advice on potential outcomes and legal representation to assist the tribunal and court in its decision-making. As much as ensuring adequate safeguards within legislative and operational frameworks is important to provide access to justice in a fair and just way, it is not the only safeguard. Legislative amendments are also not the only way to create efficiencies within the court system. Numerous evaluations and reports have shown that improved efficiencies and outcomes are achieved through applicants having access to early advice and representation compared to being self-represented. Although this bill does not go to the issue of funding legal assistance, it is important to note that whenever legislative and policy reforms occur, there are downstream impacts on the needs for support and services. This is particularly relevant in the migration sector and its need for availability of legal assistance. Increased funding for legal services can provide independent, free and credible legal advice to individuals about merits and appropriate visa pathways. This approach ensures that decision makers have access to relevant information, expediting decisions, and that applicants are given accurate advice and fair access to our administrative review system. Thank you to the committee for your time today, and I welcome any questions.
Thank you very much for that opening statement. We'll proceed to questions and begin with Senator Blythe.
Thank you very much, Chair, and thank you for giving evidence to the committee today. I'm just going to start off. National Legal Aid has not lodged a written submission to this inquiry. Can I ask you why?
Sure. We are a small team with a large scope of work in which we have to prioritise our available resources to write submissions to parliamentary inquiries. And so we do have to make difficult decisions from time to time as to which ones we can commit our time to. We also have less of our migration lawyers to assist us in that process due to the loss of funding. So I had hoped to have some of our subject matter experts being able to appear with me today, but unfortunately they weren't available. So it is a challenge, and I do welcome that even though we hadn't put in a submission, that the committee had invited NLA to address the public hearing today, and I thank you for that.
Thank you. When you say small team, can I ask you how many you have in your team and how many are directed at migration specifically?
So National Legal Aid itself has 5 staff.
Yep.
But of course, we have the 8 legal aid commissions. Not every legal aid provides migration services, but a number of them do, including South Australia, New South Wales, and Victoria, and also ACT. But they've certainly had to step back from a lot of the advice or particularly legal representation because of the loss in funding in the permanent protection visa program.
Okay, thank you. Are you able, just in a sentence or two, and I know you sort of had an opening statement that was very comprehensive, but in a sentence or two, what's your headline position on this bill?
Look, the 2 main things I would want to focus on is the expansion of the registrar's powers and whether it's appropriate in the circumstances, considering the vulnerability of these individuals, and also the notices of decision and reasons, which I've outlined. There is the concern also from us about the identification verification, but I'd say, these particular individuals are extremely vulnerable, and it's unclear why there'd be certain areas that have been precluded from making all decisions, but this particular cohort, there can be all decisions and no requirement to actually advise them of the right to ask for a written judgment.
Okay, thank you. Can I also ask you whether the Attorney General's Department contacted you to consult with you on these proposed changes to the bill?
I'm not aware that certainly National Legal Aid weren't consulted on the bill. I'm not aware of any of the individual legal aid commissions being approached on consultation.
Would you have preferred to have been consulted on this, given the scope of work you do?
Legal Aid would prefer to be consulted on, any substantive bill before the Parliament that touches on legal assistance or would have an impact on vulnerable individuals in the community who may very well benefit from legal advice and representation.
And in terms of this Senate inquiry, were you aware it was happening, or is this something you found out because you were invited to submit it, to put a submission in?
So we were certainly, we make sure that we are aware of the bills being introduced into Parliament. We monitor them. And as I say, we assess whether we have the capabilities of putting in a submission for any particular bill, whether it's an area where we can add expertise. So, yes, we're aware of the bill. And of course, we're aware that there's hearing processes that would be part of that. We weren't following the dates of those public hearings because we hadn't put in a submission. So,
thank you. In terms of, I guess, what you're experiencing, so Parliament last year, the National Legal Aid said it couldn't support the predecessor bill to this because the safeguards on oral hearings were inadequate. Now, these on the paper measures have been operating now since the 18th of May. What is your commission's actually seeing in terms of how that's playing out in real life? And does that experience change now how you read this bill?
Look, I can't give detailed advice on what we're seeing in practice. I would probably need to go back to our particular lawyers to get an update on that. But I will say that those concerns remain based on the feedback I have received from our commissions. And this bill, on top of those fairly recent changes, do concern us because it does lead to greater risk that extremely vulnerable people will not have proper access to the tribunal, certainly won't know what their rights are. Migration matters can be extremely complex. And so the more that you try to streamline it from the tribunal's perspective, and we absolutely understand that there's a backlog, that there's a need to find efficiencies, but you have to make sure those efficiencies
Is that frozen for everybody else too?
It is for me.
I'll just give it a second.
Just give it a
Yeah.
Yeah, completely gone. It's
yeah.
All right. Maybe we just give it 30 seconds to see if we can get her back online so you can conclude your question, Senator Bligh. Otherwise, we might need to move to our next one.
We can move to the next, yeah.
Tech is not in our favour today. I think Jane's looking over at broadcasting to see what's happening. I reckon we might.
I'm back.
Oh, excellent.
I have no idea what happened there. My apologies.
I was just about to call time, then you were finished. I can't recall exactly where you got up to before you all of a sudden froze. Maybe Senator.
Okay, I'm very happy to, and maybe what I'll do, just in case we're going to lose you again, but
Sure.
Perhaps if we could get some of that detail from your commissions, if you're happy to ask for that feedback from them and provide it to the committee, that would be incredibly useful for us
Sure.
to take on notice. That would be great. I guess in terms of the work that you're undertaking. We heard from previous witnesses that they're seeing about 1 in 5 clients are having, I guess, migration agents that aren't necessarily acting in their best interests, and sort of looking at, I guess for you guys, a lot of community legal centres are telling us, and the evidence that we've got is that people come to them quite late in the process. So I guess, what's your experience of dealing with perhaps migration? And I will preface this by saying that it's not 20% of migration agents that are bad. There seem to be a much smaller number than that, but they have a quite a large number of clients. What's your experience of that in the work that you and your commissions are doing?
Well, it's hard to talk to the migration agents issue, as I say, without our lawyers present, our migration lawyers present. But I would say that, we do have challenges where people may come to us quite late in the process for advice, which goes to some of our concerns around the timeframes. I understand that some of the changes in this bill, which goes to the identification verification, is seeking to deal with some of those issues. My view on that is, you're better off focusing on legislation and regulation around migration agents generally than punishing the individuals who are seeking to progress reviews before the tribunal. A lot of these individuals would have difficulty in obtaining identification documents, and we do have concerns that the Act itself or the bill itself does not state what type of identification may be required, and it's leaving it to subordinate legislation. So if the issue of, or the reason why the identification verification is appearing in this bill is because of migration agents, and as you say, only some acting inappropriately on behalf of clients or acting on, in fact, without approval of those clients, then that's where the focus should be, not on the individuals themselves who are seeking any sort of review.
Fantastic. Thank you so much for that. That's all the questions that I've got for you.
Thank you.
Thank you very much. That concludes the questions that the committee has for you this afternoon. Thank you so much for taking the time to
Thank you.
give it. Truly appreciate it. And you go with our thanks.
Thank you.
That our next witnesses are online. So I will now welcome via video conference representatives from the Law Council of Australia. Thank you for taking the time to speak with the committee today. I understand information on parliamentary privilege and the protection of witnesses and evidence has been provided to you and is available from the Secretariat. For the Hansard record, would you please state your full name and the capacity in which you appear? I understand there's a couple of you joining us online. Ms. Ford, did you want to go first?
Yes, I'm not sure that our president is yet online.
Okay.
Is that right, Alan? No, so I'm happy to go first, but we do need to wait for her to join. Karina Ford, I'm the co-chair of the Migration Committee of the Law Council of Australia.
Excellent.
Hi, my name's Alan Freckleton. I'm a senior policy lawyer with the Law Council of Australia.
Robin Craig, a member of the Law Council's committee, several of the committees, and a retired academic.
Thank you very much. I think possibly there's a bit of an IT issue. I think the secretary said that the president did pop up and then she's now not online again. So I might give her a couple of seconds just to rejoin us. It has been a bit of a theme for this inquiry this morning into this afternoon with some tech issues. So, here we go.
Okay.
Ms. Wolf, can you hear us? Excellent. I've just had your colleagues introduce themselves and state the capacity in which they are here. And now I might hand over to you to do the same and then invite you to begin your opening statement. Sorry, I know that tech issues have been a theme of this afternoon as well.
Apologies, thank you, Chair. Can you hear me okay?
Yes.
Good. Excellent. All right. Thank you. My name is Tanya Wolf and I am the President of the Law Council of Australia.
Excellent, thank you. Do you have an opening statement that you would like to make?
I do, thank you. Just bear with me for one moment, I'm sorry. Thank you, Chair. The Law Council of Australia welcomes the opportunity to appear before the Senate Legal and Constitutional Affairs Legislation Committee for its inquiry into the Administrative and Judicial Review Legislation Amendment Bill of 2026. We acknowledge the traditional owners and custodians of the lands where we are each joining from today, and we pay our respects to elders past and present and extend that respect to all Aboriginal and Torres Strait Islander people who are in attendance. The Law Council acknowledges that the Administrative Review Tribunal is experiencing high levels of applications for review and the importance of measures to ensure its efficiency balanced with the ART's own principle that it be fair, accessible and efficient. The Law Council supports several measures in the bill to this end, including assigning the President of the Tribunal to every jurisdictional area, revising the means for reappointment of members, correcting errors in orders of registrars, and clarifying that parties can apply for leave to examine or cross-examine witnesses, among others. However, the bill also continues an ongoing trend of changes to the tribunal, introduced less than 2 years into its operation, with concerning implications for procedural fairness and access to justice. This is particularly so for vulnerable and self-represented migration applicants. It's the Law Council's position that rather than introducing further legislative change, that a more holistic approach be considered, one that looks at what is causing the increase in cases, considers whether recent legislative changes, such as the Administrative Review Tribunal and other legislation Act of 2026, and subsequent amendments to regulations have had an impact, examines whether the tribunal is adequately resourced in terms of resources and infrastructure, and whether an increase in members has made a difference to productivity. Our submission identifies several measures in the bill which raise concerns. I'd like to highlight 3 in particular. Firstly, the bill grants additional powers for registrars, including the power to dismiss an application if satisfied that it has no reasonable prospects of success. This power is a significant step that should be exercised with caution, especially given its potential risks for applicants. We're also concerned that the bill does not itself contain clear, objective criteria to guide the registrar's discretion. Our submission identifies a range of additional safeguards to mitigate risk of inappropriate dismissals, noting the possibility of reinstatement under the proposed item 19C may not itself be sufficient, may not itself be a sufficient or efficient mechanism to prevent injustice occurring. Even the example given in the Attorney General's submission of a protection visa applicant being offshore as a type of decision that could be dismissed by the registrar is not technically correct if that applicant was offshore on a bridging visa B in a safe third country and intending to return. Secondly, the bill enables the tribunal to give oral decisions in certain kinds of review, with written statements of reasons to be provided only at the request of a party to the application. We recognise this measure may help save resources and time in some circumstances, including where the tribunal resolves a matter in the applicant's favour. We're concerned by its implications for access to justice in the tribunal's migration jurisdiction, including applicants' ability to understand why a decision was made, seek leave for legal advice, and determine whether there are grounds to pursue further review. We note that migration matters frequently affect vulnerable cohorts. Similar to social security, Veterans Affairs, aged care and NDIS matters before the tribunal, to which the changes will not apply. Further, these changes are likely to place a heavy administrative burden on the courts where applications are filed on the basis of oral decisions, noting that the time to file a court application runs from the time of the oral decision, not notification of the written reasons. Written reasons also assist both applicants and decision makers in improving the quality of decision making. It should also be noted that paragraph 9D of the ART Act states that the ART must pursue the objective of providing an independent mechanism of review that improves the transparency and quality of government decision making. The quality of decision making is likely to be adversely impacted by the absence of written reasons to guide decision makers when none are requested. Thirdly, there is a marked lack of detail in primary legislation about the identity verification processes in Part 12 of the bill, which may disadvantage genuine applicants with limited access to identity documents, or where those who are exploited by migration fraud, particularly as such applicants may not receive a request to respond and may then have their applications dismissed. This includes, for example, protection visa applicants who may have fled their home country without documents or who are stateless. Significant amendments of this kind should be primarily set out in primary legislation rather than regulations. To promote fairness, the tribunal should have the power to waive these requirements, as the bill otherwise provides for the Federal Circuit and Family Court of Australia. Thank you again for the opportunity to appear. We look forward to responding to your questions.
Thank you very much for that opening statement. We'll go to questions and begin with Senator Cash.
Thank you very much, Chair, and thank you for the opening.
Oh, you've just gone on mute, Senator Cash.
Weird. Okay.
Yeah, I know. What's happening?
Yeah. Okay. If I could just turn to paragraph 46 of your submission on page 11. This is something that I've been trying to work through when I've read also the other submissions. It's the bill proposes that the 35-day time limit to apply for judicial review to the FCFCOA under the relevant section would commence upon notification of the oral decision and not the issue of written reasons if requested. You then go on. The conclusion there is this amounts to nearly the entire 35-day period for prepping and filing a judicial review application to the court. Consequently, most applications to the court will be made without the possibility of reviewing the reasons for error. Applicants and practitioners would therefore be unable to comply with their obligations to not commence litigation without ascertaining prospects of success. Is this, do you think, just a drafting error that needs to be rectified? And if so, how do we rectify it? Or is there a deliberate policy choice? I'm putting that to the Attorney General's Department as well, but I'm just keen. Is this just a mistake or what actually is it?
Thank you, Senator Cash. We've just drawn attention to those time limits as they really, in practice, would preclude the applicant from, firstly, there's very little time in which to apply for or to request the written reasons. You have only 14 days after that's done, and then 14 days to review once it's 14 days for the written reasons to be provided, and then very limited time to be able to make that assessment. So we're drawing attention to the impracticality of this section of the bill. We make no comment as to whether it's intentional or an oversight, but we talk about the practical impossibility. But perhaps my colleagues might have something further to add to that.
Thank you.
Senator Ms Ford. I guess in terms of the impact, it would have a great impact in terms of being able to file on time and with legitimate grounds. It's difficult to understand why the time couldn't have run from written reasons, and maybe therefore it is something that would be benefit asking the Attorney General's Department as to why that would not be considered, because it will have an impact both on the courts in being able to process applications, bridging visa impacts, and of course the difficulty already on the registry at the court, which currently has a backlog, and it can take a number of days to even process an application where it has written reasons. So I think your question is definitely worth asking the Attorney General's Department.
Sorry, I'm not touching this. It puts me on mute the moment I have finished. I do apologise. I didn't realise that. Can I just clarify then that if a change needed to be made, the change you're proposing is from the written reasons, the time would commence?
Correct.
Thank you very much. Just going back to what Ms Wolfe was referring to in relation to the registrar dismissal powers, and at paragraph 18 of your submission, you set out, as you went through, the mitigation of risk of inappropriate dismissals, as you call it. If the government adopted all 4 of these, or some of them, would you then support part 1, or is your objection to registrars exercising merits judgment at all?
Thank you, Senator. Again, I'll let my colleagues expand upon it, but primarily we have concerns with it. But if it is going to be legislated that registrars are making these decisions, and they're significant decisions, that at least, at the very, very minimum, there be these additional safeguards. But perhaps I can invite my colleagues to talk further in relation to that.
I'd like to add something to the discussion on that issue. At present, of course, there are some 6 categories of registrar within the tribunal, and they vary in levels of experience and in qualifications. So it is clear that in some cases, the registrar will be perfectly able to handle certain types of dismissals. They already are in a position where there are no jurisdictional withdrawals, will often be making decisions of this kind. And under the current legislation, they do have the powers to stand in the shoes of the original decision maker, which means making some decisions. So the qualifications and experience of the registrars will determine whether or not they're suitable for handling some decision making. And hence, in our submission, we talked about a need for caution and a need for objective criteria against which the particular registrar is authorised to make decisions, particularly where they are of a complex, either legal or factual basis. So to answer the question, we would not oppose completely part 1, but we do require that the powers of registrars in these contexts should be exercised very carefully by appropriately qualified and experienced registrars.
And when you say appropriately experienced, the exact wording is and sufficient post-admission experience, what do you determine that to be?
The experience would be of the type of matter which is involved. The experience would also be possibly of their the amount of time they've spent exercising powers within the tribunal, because, as I say, they currently have quite significant powers within the tribunal to advise clients and applicants about the evidence that they should be providing, the likelihood of success of the claim that they're going to is being developed. And for all of these reasons, their experience in that quality, in that context, or also in the context before they joined the tribunal. For example, a significant proportion of the registrars have legal qualifications, and many of them would have been in practice before they joined the tribunal. So again, choice of particular registrars to exercise particular powers is going to be very important.
Thank you for that. Could I turn to paragraphs 23 and 24 of your submission on, I've got page 58 of my documents, it might be different to yours, but paragraphs 23 to 24, a power to remit applications. Is this power in addition to what is currently being proposed by the government in this legislation, or is it to complement, is it in addition, or is it in substitute of, for example, paragraph 18?
It would be in addition to. In
addition, yes.
To allow.
So it's not currently proposed. It's something that you're saying the bill could also contemplate a power to remit applications.
Correct. And as you would have seen, Senator, the examples we're given are very much objective criteria that would make it an easy decision to remit, unlike some of the cases that would be within the dismissal power, like protection visa applications, which are very subjective criteria and often unrepresented. So it's just another suggestion of a way that could allow for productivity within the tribunal, particularly in matters that could be dealt with quickly and remitted back.
But that's excellent. No, I really do appreciate that. Chair, that is all the questions that I have. Thank you very much.
Thank you very much, Senator Cash. We'll now move to Senator Shoebridge.
Oh, thanks all. And I really appreciate your submission. I think if I understood your position in response to one of Senator Cash's questions about the increased powers being, well, the fresh powers being proposed to give to registrars to dismiss matters, basically on the papers, is that something you think would be a good power if it was appropriately, limited, or is it a power that shouldn't exist and your limitations are simply there as a way of trying to sort of ameliorate an otherwise poor piece of statutory reform? Where do you sit on that?
Maybe if I can answer that first and then hand to the others. I think the difficulty with migration decisions, they're not generally objective, and they do require a level of assessment that is at the level of a member. There might be some cases that could fall within it. For example, a case of English language testing wasn't attached to a time of application case. But overall, there is a level of assessment, and a good example is even the student visa caseload that's moved to decisions on the papers still requires the criteria to be assessed because it's subjective. So I honestly think that there isn't much that can be gained by introducing this, and obviously, unless it has safeguards, it's actually potentially going to lead to more work because you're going to have reinstatements and then have the issue with a backlog to the court.
So put simply, your position is this is not a power that should be given to registrars.
Yes.
Okay. Yeah.
Yes.
And you've put some helpful proposed checks and balances if for some reason the Parliament thinks it's a good idea to give it to registrars, it should at least come with these checks and balances.
Correct.
As I understand it.
Yeah.
Terrific. Could I ask you just about one of the issues that's raised repeatedly is that registrars are employees of the tribunal. They go through a very different selection process to tribunal members. One of the, touted reforms of this new tribunal from this government was that the appointment process for members went through a rigorous and at least somewhat independent assessment process. Could I ask you to speak to that and the difference between that sort of public confidence for tribunal members as against registrars? Not to cast shade on registrars, but to point out the difference, the fundamental difference.
I'm so sorry, Senator Shoebridge. I missed the first part of what you said. I don't know if everyone else is.
Yeah, sorry. The parliamentary tech is not amazing. Maybe I'll speak more loudly. There is a very real difference between how registrars are selected and appointed to how tribunal members are selected and appointed. And it's one of the reasons why that registrars traditionally only have very limited procedural powers to run directions, hearings and the like, and aren't given decisions to make substantive determinations about questions of justice or merit. Can you speak about the difference the Law Societies, the Law Council sees between the rigour in appointing tribunal members as against registrars?
As you would be aware, Senator, the Law Council did numerous submissions about the importance of transparency and an appropriate appointment process with tribunal members. And that was one of the highlights of the ART bill and legislation. I think with registrars, if you start to add that subjective criteria, that is where potentially you will have an issue, because that has been a problem with the tribunal previously, where there wasn't objective criteria in selection. So, your point is a valid one, and it probably again supports the reason why it is important for members to be making decisions on substance.
Yeah, and it's a simple and principled point. Substantive decisions should be made by appointed members, not by employees in the form of registrars. That's a fairly simple point, really, isn't it?
Correct.
Yep. There is significant concerns about the mandatory dismissal provisions. Significant. I see you address this in your submission as well. But what has become apparent as you read through the submissions, and we've heard some of the evidence this morning, is that requirement is going to potentially create the greatest potential for harm and unfairness amongst some of the most vulnerable cohort coming before the tribunal. Can you speak to that?
I'm happy to start, and I know that my colleagues will have far more to say about this, but I think that is a significant problem that we have actually running through the three principal areas of concern that we have in relation to this bill, that each shifts risks onto the most vulnerable, self-represented, under-resourced applicants. And the safeguards that are offered in each case, reinstatement or a request mechanism or judicial discretion, is itself very hard for those applicants to use and to navigate, and absolutely in relation to the dismissal as well. But perhaps...
And maybe speak to some of those particularly vulnerable cohorts. One of the examples that was given to us was a woman in a violent domestic and family violence, may have had the passport held and hidden from them as part of coercive behaviour. They're particularly vulnerable in this situation about potentially having the mandatory dismissal happen. But that's one cohort that comes to mind, but there may be other vulnerable cohorts.
I think in particular you're talking here about the identity provisions that it would allow a dismissal, which interestingly, for some reason, there is the ability to reinstate at the court, but not at the tribunal, which I...
Yeah, but in fact, you say allow, but my understanding is it's mandatory dismissal.
That's right, it is.
Which is even more dangerous.
Yes, that's correct. And in terms of vulnerable caseloads, I mean, there's many. They include obviously those clients that don't have a lot of identity documents, which still is a lot of people. Also includes vulnerable child protection cases. So there are quite a number of cases of where children who have been in child protection due to processing are over the age of 18 by the time the case processes. Some have no identity documents because they've left a situation where they've never held their birth certificates, or they've never had a passport, or if they have had a passport, they've never held it in their possession. And then the other cohorts would also include, particularly with that dismissal power relating to identity, is where you have shadow agents that have lodged an application and used a false email address, which would appear to look like the person's name, but the person has no ability to access it. And I think that was sort of part of the purpose of those changes, but what comes through, it actually punishes the applicant as opposed to correct the issue at hand. I think, Ellen, you're on mute.
Well, if anyone else wants to add to this.
Can I just say one thing, Senator, and that is that a safeguard against this power would be that the applicant is required, the tribunal is required to give notice to the applicant that they're proposing to dismiss. And this isn't in the current legislation, and that would be an important guardrail in the circumstances.
But if you're a Hazara, for example, from Afghanistan, and you've had to flee and you haven't had a passport and you don't have travel documents, the Afghan embassy has closed now. They won't be able to go back to, refer back to Afghanistan, to the Taliban for documentation. I mean, that's a cohort you think could face mandatory dismissal because they can't provide the verification.
Yeah, and
also a
exactly
on from Myanmar would be in a similar situation. Sorry.
Yeah.
No, you're exactly right, President.
I think another point to make here is that the Federal Circuit Court, I should say, is going to have the power to waive identification requirements, but not the ART. And it seems rather difficult to justify the difference.
But I mean, you would have thought that at the lower cost entry point, if a Hazara family is here and say we haven't got passports because we fled from the Taliban, they were causing us for fear of our lives. We didn't have travel documents when we fled. The embassy has closed. We can't get travel documents with them. And if we went back to the Taliban now, they may kill my family. You can't give that explanation to the tribunal, and you're facing mandatory dismissal. Who would design such a system?
Yeah, I think also some cases, in fact, are exactly on identity. So the decision may have been refused on the basis that the applicant hasn't been able to establish identity, and there are a number of Afghan cases in that cohort. And so you'd actually have a situation where potentially they couldn't appeal, or their application would be dismissed on the basis that they couldn't prove who they were, but that's the whole purpose of the review. So that is ludicrous, and I think, in all honesty, this part needs to probably be reconsidered. It would have benefited from maybe getting some feedback from like the Law Council and other groups about what it was trying to achieve, rather than just bring a bill forward and not fully explaining how it's going to work.
Like, this one should be like, go back and do your homework and bring a bill that works.
Exactly, and outline what it's trying to achieve, because there may be ways you can do it without legislation, for example. Not everything needs to always be done through a bill. It might be practical elements within the tribunal and the court to ensure that the person knows what's going on in their matter.
Don't give them too many ideas, Karina. Anyhow, unless someone had anything to add to the questions I've put.
Senator, at the very least, there should be a waiver power so that there is discretion on the part of the registrar before any dismissal takes place or identity documents are required. and any mandatory dismissal is discussed.
But coming back to your earlier point, you can't ask for a waiver if you don't know the power is about to be exercised.
That's right.
Matter's just gone. Which is, again, like the problem with this whole design. The design seems flawed from the outset. But Chair, thank you for me in that. Appreciate it.
Thank you very much. I was going to hand the call to Senator Cox. She's indicated that actually her colleagues have asked the questions that she intended to ask. So that does conclude the time that we have with you this afternoon. Thank you very much for taking time out of your day to come and speak with the committee. Appreciate it. We will now suspend for lunch and return at 1:30. Thank you very much. All right, I think we've got almost the full suite back, if not everyone. So I might kick us off. I now welcome, both in person and via video conference, representatives from the Administrative Review Tribunal, Attorney General's Department and Department of Home Affairs. Thank you for taking the time to speak with the committee today. Information on parliamentary privilege and the protection of witnesses and evidence has been provided to you and is available from the Secretariat. I remind senators and witnesses that the Senate has resolved that an officer of a department of the Commonwealth or of a state shall not be asked to give opinions on matters of policy and shall be given reasonable opportunity to refer questions asked of the officer to superior officers or a minister. This resolution prohibits only questions asking for opinions on matters of policy and does not preclude questions asking for explanations of policies or factual questions about when and how policies were adopted. For the Hansard record, could you please each state your full name and the capacity in which you appear? And I might start in the room and down the left-hand side of the table. That's the right-hand side for me, sure.
Dylan Adams, Director, Courts, Jurisdiction and Powers, Section, Attorney General's Department.
Good afternoon, Rachel McDonald, Acting Assistant Secretary, Federal Courts Branch, Attorney General's Department.
Good afternoon, Sarah Kapadia, Acting Director, Administrative Review Tribunal Policy Section, Attorney General's Department.
Good afternoon, Miss Nadia Vittoria, Acting Assistant Secretary, Administrative Law Branch at the Attorney General's Department.
Tara Inverarity, First Assistant Secretary, Courts, Tribunals and Commercial Division, Attorney General's Department.
Andrew Kiley, First Assistant Secretary, Migration, Citizenship and Humanitarian Division, Department of Home Affairs.
Thank you, and then we'll go to online. Mr Hawkins.
Good afternoon, Michael Hawkins, CEO and Principal Registrar of the Administrative Review Tribunal.
Hello, I'm Deborah Tate, Principal Lawyer at the Administrative Review Tribunal.
Thank you. Ms Tate, I might get you to just move a bit closer to the computer microphone because we might struggle to hear you throughout the rest of the afternoon. Thank you very much for that. Ms Winton.
Good afternoon. I'm Sally Winton, the First Assistant Secretary of the Migration, Litigation and Information Division within Legal Group with the Department of Home Affairs.
Excellent. Thank you. Now, does anybody have an opening statement?
No, I don't think anyone has an opening statement. Happy to go straight to questions.
Excellent. We will do just that and begin with Senator Cash.
Thank you very much, and thank you all for appearing. And I do acknowledge that I have been given a briefing on this bill. So there is one question I did say that I would ask, though. It's in relation to, and I'm happy for this to go to all witnesses and those who believe they can answer it to respond. Every non-government submission converges on a similar concern. The 14-day plus the 14-day reason timeframes colliding with the 35-day judicial review window, mandatory dismissal at the tribunal against discretion at the court, and the substance of the identity verification scheme sitting in regulations that don't exist. Could I turn to the 14 plus 14 and just that alleged collision with the 35-day judicial review window? Is that something that the department has looked at and said, yes, that is a concern, it needs to be addressed, or it is acknowledged and that is just the way the legislation is drafted?
Thanks. I might ask Ms Vittoria or Ms Kapadia to speak to that part of the bill.
Thanks, Senator. So that's correct. If a person wishes to seek judicial review under the Migration Act, the application would still need to be made within 35 days from the day the decision is taken to have been made. So that's when the decision is given orally if the tribunal chooses that pathway. As you said, that's correct. The applicants would have 14 days in which to request written decisions of that decision made by the tribunal, and if requested, the tribunal would have 14 days in which to provide them. And so that's correct. And it is the case that you can apply for judicial review without already having a copy of those written reasons.
Oh, yeah, okay, I understand that. Okay, so technically there is a 35-day window. What others are therefore arguing is that it should commence from the written decision, understood. Can I just ask, A, why does it commence from the day that the decisions are given orally? And what would be the effect of delaying that until the written reasons are given? Obviously, I'm assuming it's a blowout in the efficiencies.
So I think the delay might create some interactions with the timeframes for judicial review under the Migration Act, and also noting that an applicant's review rights interact with their visa status, and those timeframes that also apply under the provisions of the Migration Act. So as is currently the case, applicants seeking appeal would have 35 days from the date of the decision.
So I think...
Okay, so this is a deliberate drafting and it is intending to work as such, despite what's been raised by other submitters.
I believe, and I'll let my colleagues correct me if I'm wrong, or Michael, if you have anything to add, the appeal stems from the date of the decision, which along with the reasons can be given orally. Then the 14 days applies to get the written reasons. The decision obviously has already been given. Then if someone takes the maximum of 14 days, the tribunal would then have up to a maximum of a further 14 days, and a person would still have 7 days after that if the maximum time was taken by both parties to give the written reasons, noting that the decision would have been given. But Michael, was there anything you would like to add to that?
Yes, Tara. Senator, I'm not sure what the others have submitted, but this is not unusual. This is not terribly different to the situation we have in Section 501 detainee cases, where a decision can be made on a day and then a member might have a reasonable time. We call them Khalil decisions, where they might have a reasonable time then in which to submit the reasons. And the President has determined in a practice direction that a reasonable period from his perspective is 21 days.
Understood. No, okay. As I said, I just wanted to clarify, it has been deliberately drafted, and as you stated, it is sort of no different to, say, the Section 501 cases. The decision is the decision, whether given orally or in writing. And in this case, orally is what would start the clock. You can still apply for the written reasons, but the clock has already started. Does that summation sound right?
It does, Senator, and even if the maximum time was taken to request and then provide those reasons, there would still be time left within that 35 days for...
The 7-day period.
Exactly,
yeah. Understood. So
Senator,
oh, sorry.
Apologies. I might just add that there is an ability under Section 477 of the Migration Act to seek an extension of time to apply for judicial review. And in practice, the Commonwealth as a model litigant would take that into account in terms of the position it would take on such an application if the circumstances were that there had been delay in the provision of reasons.
And again, I might just ask Mr Hawkins, my understanding is the tribunal provides information to people about their appeal rights, in which information about timeframes may also be able to be included?
Yes, Tara. In the decision itself, we provide comprehensive advice as to what appeal rights exist and timelines.
Thank you for that. Could I just turn to the Law Council's submission? They recommend at paragraph 18 that the dismissal power be confined to legally qualified registrars. Can I ask in the first instance, is there any qualification for the registrars? Like, is there any particular power or should I say qualification they need to have? And if not, and take this on notice if you need to, this is to the tribunal, how many registrars does the tribunal have in total, and how many of them are admitted legal practitioners?
I might ask Mr Hawkins to speak to that.
Yeah, Senator, I'll have a crack at that for you. The Act prescribes that a registrar must be either legally qualified, have ADR experience, or such experience as the registrar might consider appropriate. Now, at present, we have about 110 registrars. I don't have the precise number, but the vast majority of those are legally qualified or have ADR experience. In fact, I'd go so far as to say that most registrars would have at least 2 of those qualifications, because if they have neither legal nor ADR, they would only have the role if they had extensive knowledge and experience of the tribunal's practices and procedures.
Thank you for that answer. If I could have on notice just the actual number of legally qualified and the number with no legal qualification but ADR experience. Sure. Can I ask then, and again, this is to whoever would like to answer, would it be an issue if that power was then combined to those who are legally qualified, given it would appear to cover the majority of the registrars?
Senator, I'll have a punt at that one again. The legislation empowers the President of the Tribunal to direct or to authorise registrars to have powers. So he can actually impose conditions on the authorisation that he authorises. So in some instance, for example, he might decide that a registrar must be legally qualified.
Understood. Okay. Does the department have anything they want to add to that?
No, Senator, I don't think so, other than a goal of the department and the government is to allow discretion to the tribunal and particularly the President to make decisions about what is appropriately authorised to registrars within his or her decision-making power, and we think this strikes that right balance of allowing the President to make those decisions rather than it needing to be prescribed in primary legislation.
In the Law Council's submission, and again, if you haven't had an opportunity to review it, more than happy for you to take this on notice. This is both to the AG's department and to the tribunal. They, at paragraphs 23 and 24, refer to an additional power that the tribunal may like to consider, a power to remit applications. And they say consideration could be given to the delegation of powers that may be exercised in favour of applicants where appropriate. For example, registrars could be given the power to remit applications for redetermination where it is apparent that the original decision is plainly an administrative oversight or where the decision maker failed to consider material that was available or could readily have been obtained. They then give some examples of such remittal powers. Is that something that has been considered? Is that something that perhaps consideration could be given to that would add to the efficiencies the tribunal is seeking?
Mr Hawkins?
It is certainly an efficiency. Wouldn't mind you moving an amendment to that effect, Senator.
Senator, we're happy to take on notice having a look at that suggestion in the Law Council submission. I myself haven't turned my mind to that, so we might come back to you on notice if that's okay with any thoughts about...
as I said, more than happy for you to do that. Yeah, paragraphs 23 and 24.
Thank you.
Just in relation to, and it might be that Senator Shoebridge is going to pursue these questions with you. And if he is, jump in, Senator Shoebridge, and just say, Senator Cash, I'll be taking care of this. But it was in relation to the substance of identity verification. And in particular, the Hazara, for example, or those coming from places. The Taliban.
I was going to do this, Michaela, but I'm more than happy for you to get started and get this first question.
What I was going to say is I think he's raised a very relevant point. If you cannot, the Taliban does not give out identity documents, in particular to people who are here in Australia, if you don't already have them. Can I just ask, has the department or tribunal given any consideration to, or is there something in the bill that you could point to that would actually assist these people? Because otherwise they're going to be knocked out before they even get a chance to actually put their case to you.
Yes, thank you, Senator, and in anticipation, Senator Shoebridge, for that question. I think the thing I would say is that the need for alternative proofing arrangements for people with no or low identity credentials is an issue well known to government. The National Identity Proofing Guidelines were reasonably recently updated to provide best practice guidance about how to do proofing of identity, both for people with a full suite of the traditional types of identity documents that we would be familiar with and probably hold ourselves, but then also alternative proofing arrangements for people who do not have that same privilege of having identity documents, which can be a range of vulnerable Australians as well as the types of cohorts that arise in the migration sector. So identity verification is something that is already part of primary decision-making processes managed by the Department of Home Affairs, and we would expect to benefit from their experience, but also to be informed by that policy guidance that the Australian Government has also issued to support alternative proofing arrangements. I'll just check if Mr. Carley wanted to say anything about how that's managed in the primary stage.
Thank you. All I would add to that is at the primary stage, all these individuals would have gone through a primary decision onshore, and consideration of identity, including those alternate arrangements, would have been considered at that primary stage as well.
Thank you for that. Just in terms of the draft regulations for Part 12, when do we anticipate them being available?
Sorry, Senator, your sound just drifted away at the end there.
Oh, not a problem. The draft regulations for Part 12, when do we anticipate them being available?
That they're still under active development and consideration, and we will need to work closely with the Tribunal and the Federal Circuit and Family Court of Australia Division 2 to assist to develop those processes and practices. Mr Hawkins, I'm not sure if you wanted to say anything about the work that has already been done in the Tribunal.
We are awaiting the regulations as well, Senators, to see what the impact will be on resourcing and how we will resource it. Obviously, there'll be in-person ID verification. There will be apparently online. So we're really just awaiting the detail.
So, and thank you for that. Okay, so we are tabling, I understand, our report on the 7th of August. Are we going to be able to assess the regulations prior to that?
Prior to that, I think is unlikely, Senator, but I myself don't have a timeline for when those regulations might be ready. So that will be something we're happy to take on notice and get back to you on.
Yeah, no, I would appreciate that. At this point, Chair, I don't have any further questions. I'll just liaise offline, though, with Senator Blythe.
Thank you very much, Senator Cash. Senator Shoebridge.
Thanks very much. Could you outline to me the processes that have been employed to date to employ registrars? What's been the process to date to and registrars? I think they're not members; they're employees of the tribunal. Is that right?
That's correct, Senator. So registrars as employees of the APS are employed in accordance with the processes of the APS. So it's a merit-based process. The qualification.
And they can be sacked if you don't like. They can be terminated. But is it you who can terminate them? Who's their employer?
Yeah, as their employer, as the agency head, I would have that power. Yes.
Yeah, and there's no, but there are protection measures in place for tribunal members. Is that right? You can't terminate tribunal members. I'm not
maybe I can jump in there. Sorry.
I suppose I'll just finish the discussion with the registrar and then I'll go to the department.
It's just the Attorney General plays a role in termination of members of the ART rather than the tribunal itself.
That's what I'm exploring at the moment with the registrar. So registrar, just to compare the powers that you have, you, for example, can terminate, using your authority, your statutory position, you can terminate registrars and you don't have to seek Governor General's approval or the Attorney General's approval. They're employees, effectively.
Correct, they're APS employees.
But tribunal members, you don't have that power over.
I have no responsibility at all in relation to that.
And that's an important check and balance, isn't it? So that tribunal members, if they're making merit-based decisions, have a statutory independence and may not like what they do, but that's the statutory independence is a critical part if you're having people make merit-based decisions in your tribunal, I would have thought.
That is.
But you see, do you support the registrars having the ability to make merit-based decisions and dismiss applications without those protections?
The powers that are being given to registrars are generally procedural in nature.
But this bill isn't. This bill allows them to be dismissed, to actually dismiss applications. You're not calling that procedural, are you?
Well, if they don't comply with a requirement, for example, it's not really a discretion, the fact that they don't have the, for example...
No reasonable chance it will succeed. You're not suggesting that that's a procedural power, right? I mean, if you are, that's fine. Tell me you think it's a procedural power, but is that really what you're saying?
Yeah. We don't...
You think it's
we generally don't authorise registrars to have a power that involves a discretion.
Well, if they form... I mean, it's a subjective determination based sometimes on the merits of a case, whether or not a matter has a reasonable chance to succeed. In any... I've got to tell you, you may have a different view, but if so, I find it incredibly challenging that you think it's a different view, because it's clearly a merits determination.
Registrars would only be exercising powers that are objective. If a person, for example, doesn't have an enrolment certificate, objectively, they don't have it.
Where does it say that in the bill?
I think this is what we expect the President would express in any authorisation of what registrars would be empowered to do, would be likely to limit that dismissal power only to matters where it's being exercised based on clear and objective criteria. But Mr Hawkins can correct me if that's incorrect.
Sorry, just to be clear though, I'm looking at the bill. Is this anywhere in the bill? And did I miss it in the second reading speech? Was there clear statements about it in the second reading speech saying it would only be objective criteria? Was it either in the bill or the second reading speech?
I don't believe it was in the second reading speech.
Is it in the explanatory memorandum?
I don't believe so, but it could certainly...
It's not in the second reading speech, it's not in the explanatory memorandum, it's not in the bill, but we should all be okay with it because there will be these checks and balances somewhere over there.
We're happy to take on notice whether it could be expressed with greater clarity in either the explanatory materials or whether there's any scope to include it in the face of the bill, on the face of the bill itself, given that is what we expect the authorisation would be. But ultimately, that is what we expect and would be consistent, if I understand what Mr Hawkins is saying correctly, with how registrars exercise other similar powers.
Was it your expectation, though, was it the department's and the government's expectation when they drafted a bill without any of those checks and balances? Was this always your expectation?
Our expectation is that as professional officers of a highly functioning tribunal, that registrars would be acting appropriately when exercising this power and would be operating under an authorisation that a highly qualified president had seen fit to express. So that's the expectation, but as I've said, we can take on notice whether that can be expressed with greater clarity.
Well, could you answer? I mean, that's a generic set of boilerplate statements you've made, and so I'm asking you a very specific question. Was it your expectation, was it the government's intent to limit these powers to only where there were clear procedural or evidentiary defects of the nature that the registrar has indicated these powers should be limited to? And if so, why wasn't it contained in the bill?
The powers were developed in close consultation with the tribunal. They were developed with that understanding in mind. I personally cannot speak to why the bill itself does not include those precise words. I suspect it is to ensure that the President can also express his authorisation if another alternative appropriate case emerges where registrars should be able to use this power. So, as I said earlier, we trust the President of the Tribunal to manage the registrars and their powers appropriately. But if this is a limitation that is considered important, then it's something we're happy to consider.
Well, if you can't speak to it, did you bring anyone here who can speak to it, who had a role in drafting the bill and can answer these pretty fundamental questions? You say you can't speak to it. I can't see fully everyone who's at your table, and I'm not quite sure who Ms Winton is. But is there anyone who was involved in drafting the bill who can speak to this question if you can't?
I can say that, as Ms Inverarity has said, that the President will place conditions on the authorisation given to the registrar to exercise the powers. In the explanatory memorandum in paragraph 31, it does say that it's expected that this power would only be exercised by registrars where an application has no reasonable prospect of success based on clear objective criteria, such as that an application is bound to fail.
Bound to fail? How is bound to fail an objective criteria?
Well, we have
bound
some
to fail
examples.
Could be because, just let me finish. Bound to fail could be, well, I think the evidence doesn't stack up, this is bound to fail. Bound to fail could be, I don't like the legal argument, I think it's bound to fail. How is bound to fail an objective criteria? Can someone explain that to me? I can't comprehend it.
Well, we can give you some examples if that would assist.
No, if you could just answer my question. How is bound to fail an objective criteria?
Point of order, Chair. I think the witness is being quite reasonable. If Senator Shoebridge would maybe take a breath and allow her to answer the question.
Well, I think
the witness did ask. The witness did ask.
That would be beneficial for everybody to hear instead of badgering witness and constantly.
The witness did say, I can give some examples if it would assist, and to answer the question, no, that would not assist. Can you please answer my question?
Senator Shoebridge.
No, you want an answer she can't give you.
Senator Cox was... No, sorry, I'm speaking. Senator Cox was in the middle of a point of order before you started to respond. I think what is appropriate right now is just the reminder to treat witnesses with dignity, courtesy, fairness and respect, as we are all obliged to do.
Thanks.
So I would remind all of us that that's our responsibility. And while I've got the call, I will also just remind people that we are due at 2 p.m. to have the National Emergency Warning System come across all of our devices. And when that happens, I will just take a very short suspension until that concludes. So Senator Shoebridge, with the remainder of time.
Thank you. I wait for the alarm. So no, the examples wouldn't assist to answer your question. But could I ask you to tell me why you say bound to fail is an objective standard? Is that actually the position of the department, that bound to fail is an objective standard?
There are objective reasons why a application would have no prospects of success. The examples I was intending to give you would demonstrate that, but if those examples would not assist, we can take it on notice and see what else we can develop.
But I'm sure there are cases you can point out where there would be that would meet an objective test, such as critical documents not being provided. But that does by no means bound the operation of that term. And I was hoping you would actually, I mean, if it is the Attorney-General's position that the test of bound to fail is an objective test, if that seriously is your position, I would appreciate you articulating that. I would appreciate you articulating that in some detail here. And if you can't articulate it in detail here, provide it on notice.
I think you're misrepresenting what I'm saying to you. There are objective requirements in tests which, if they are not met, would make an application bound to fail. They may include things like a person must be onshore and they're not. A person must be of a certain age and they're not. If such an objective criteria was not met...
Thank you. We will suspend briefly until the... to recommence?
Yes, the alerts have ceased here at least. And I think what I was...
I'm just checking that Senator Shoebridge has rejoined us before you begin responding again. Yeah, thank you. Please proceed.
I think I was pretty much done with my answer anyway, which was when objective criteria such as that, which are quite different to whether documents are provided, are satisfactory, etc. If an objective standard that is a yes-no is not met, then we would argue that in those circumstances an application is bound to fail. There will be a range of other scenarios that meet that test, and then there will be some that do not, and there may be grey in the middle, which is where I think the President's authorisation can assist to provide guidance about when a registrar can and can't exercise that power.
What is the process for appointing a registrar?
I'll defer to Mr Hawkins on that.
It's a merit-based process, Senator, that we would set out selection criteria. People would respond to the selection criteria. We have a panel that would assess, interview and appoint, and recommend appointment.
And who makes the decision about appointment?
I've probably delegated that to the Executive Director of Registrars.
But it's a power exercise under your delegation.
Yes.
Right. So it's your power that you can delegate to other officials. And in terms of tribunal members?
Tribunal members are appointed by the Governor-General on the advice of the Attorney-General under merit-based processes set out at some detail, as you'd be familiar with, particularly in the Administrative Review Tribunal regulations. And if you, I know you mentioned termination processes earlier, I might just cover that off as well in case that's relevant. Also, termination of members is a power that vests in the Governor-General, again, exercisable on the recommendation of the Attorney-General. The Attorney-General consults the President, as she is required to do, on both appointments and terminations, if they are to arise.
And that's for courts?
Pardon, sorry?
There's a statutory criteria for the basis of the termination. It's not an at-large power.
It's all set out in the Administrative Review Tribunal Act, that's correct.
And there aren't such provisions for registrars, correct?
No, as APS employees, there are a range of other, frameworks that apply in that scenario.
Registrar, can I ask you about migration decisions? Refugee matters, for example, asylum matters. They can often be complex mixture of fact and law, which and some of those decisions can run to many pages as they're going through complex matters of fact and law. Would that be a fair observation?
Very fair.
And often, if there's legal challenges to it, can be quite complex jurisdictional challenges about failure to take into account a relevant material, giving weight to irrelevant factors, errors of law. It can be can require quite a sort of close analysis of the decision in order to articulate those kinds of legal challenges, can't it?
The legal challenge to the member's decision?
Yes.
At the Circuit Court, yes.
Yes. If somebody is sitting there and English is not their first language, they may have very limited English, they receive a decision like that orally, could you seriously suggest that they would be in a position to either instruct lawyers or inform some advocate about the nature of the decision in such a way that they could begin to formulate a credible legal challenge, having heard it orally?
So, Senator, the decision itself is in writing. At the time of delivering that decision to the applicant, they would be advised that they have an opportunity to seek the reasons in writing.
But that doesn't answer my question. So I'll go back, I can rephrase it again. You probably remember it.
If you could, yeah.
A minute ago. Given the nature of those decisions, complex mixture of fact and law, you're not seriously suggesting that somebody who, for example, English wasn't their first language, would be in any way capable of communicating that detail to a lawyer, having heard it orally, in order to start mounting a credible legal challenge. You wouldn't be suggesting that, would you?
No, I understand that. But the applicant may still seek for the reasons to be provided in writing.
Yeah, and they have, and how will they be informed of that?
At the time of making the decision, when we communicate the decision and when we deliver the written decision to them,
and so
that as they would be of their appeal rights to the Circuit Court.
So as they're being given a lengthy, quite often incomprehensible decision about their life, a critical matter of their life, the end of result of which may be devastating for them, they will also be orally told that they have 14 days to seek to have that in writing, and they'll also be told that they could challenge it. And they're going to digest all of this in like what for them might be an utterly devastating 45 minutes of their life in this tribunal, and that's what you're suggesting will happen?
No, I'm also suggesting that at the time the written decision is provided, which must be provided, there's distinction between decision and reasons, as you know. When we provide the written decision, we can't get away from that. That's when they'll be advised of their appeal rights and also their right to seek the reasons in writing.
And when do they get their written decision?
Whenever it's produced immediately after the hearing.
And so they're given this potentially quite lengthy and complicated oral judgment decision, and then they get given probably one, if they're thinking of appealing it, your application has been dismissed. And then at the bottom of that, there will be some information about their rights to seek that complicated oral decision to be in writing.
Yes.
In practice, I imagine that complicated long decisions will probably be largely written out by tribunal members and they'll be reading them. Is that the likelihood of what's going to happen?
No, I've got to make clear first, we're actually reinstating a practice here that was in the AAT. So this is not new. We had this power back in the AAT. I would expect that a very complex decision would not be delivered orally. But it's not to say that a very experienced member might not.
So do you want me to repeat the question?
Sure, please.
In many of these cases, it'll be delivered orally, but from a document that's in writing. That I assume would be the expectation. You deal with tribunal members. When you're talking with them about this and you're wondering how this is going to work in practice, you must have actually had some of these conversations. I imagine that, many times it will be in writing and they'll be delivering it orally, but you're the one who's been having the conversation with tribunal members. Tell me what their expectation is.
Yes, if a member writes it, and I can't speak for the members, of course, but if a member has taken the time to write a decision, the member would probably produce it in writing.
rather than presented orally.
Yeah, I was just going to, sorry, may I just reinforce it just to make sure we're on the same, proceeding on the same footing. It's a discretion for a member to provide reasons orally. So if they had undertaken the process that you've described, Senator Shoebridge, to write it out, it may be a situation where they do not seek to exercise that discretion and instead provide the reasons in writing if they have effectively already been produced.
I have read the bill. I do know it's a discretion.
I was just seeking to clarify to ensure that we were proceeding on the same basis.
Cool. Registrar, what proportion of matters do you think is it intended to allow for, or to have oral decisions? And do you have a particular sets of caseloads that you think are more likely to have oral decisions than others? And what's the thinking?
I'm thinking that they would probably be set-aside decisions where the applicant is the victor, so to speak. The applicant is happy with the outcome, doesn't really need to know the reasons. Probably very straightforward decisions. In cases where it is a set-aside, then it's up to the department whether it seeks the written reasons. Would you think of any others? So probably the very simple ones, student visas, if they don't have an enrolment statement, you'd say why?
But I imagine that these are cases where these decisions have been made hundreds or thousands of times, and there's incredible database of prior examples in this, where largely what you'd be doing is repeating something that's been done 1,000 times before, but changing the names, the date of birth, and the application number in many of these cases. If it's that set of decisions.
Yeah,
is that right?
But as Ms. Inver already said, this is a matter of the discretion of the member.
No, but you were pointing the cases that the examples that you've given, each of them seem to me to be an incredibly standardised judgment, which most tribunal members, if they've been working in the field for any length of time, would have given dozens of times themselves. The tribunal would have delivered thousands of times.
Yeah, sure.
All of the examples you've given. Do you agree?
Yeah, and quite often.
So then what is the difficulty with requiring, where's the efficiency gain in having them delivered orally? If ultimately what it is I've given this 1,000 times before, I'm just going to insert the applicant's details in this particular case, the respondent's detail in this, and I'm just going to produce it in writing. Where's the efficiency gain here if that's the cohort you're talking about?
Is the immediacy of the decision, Senator. If you are giving an oral decision, you can give it at the time of the hearing. Otherwise, you're going to be sending the applicant away and then setting about writing the decision.
No, you could say, hold on 5 minutes. I'm going to go and think about it. You go, hold on 5 minutes, and you delete David Shoebridge, insert Michael Hawkins. Decision made. But instead you're proposing to have this whole new statutory criteria, requests coming afterwards, potential delay. How would saying, hang on, hold on 5 minutes, I'm just going to produce your decision? How is that realistically a delay?
I'm going to before you respond to this question, I'm just going to indicate, Senator Shoebridge, coming up time for your block of questions. I just wanted to check in.
I've got one more matter I'll come to after this, Chair.
Yeah, okay. Thank you very much. Helpful. Thank you, Mr. Hawkins.
So, Senator, I think we're focusing on the very simple ones, but there are also a significant body of work where you might set aside a matter. I've done it myself in the protection caseload before when I was a member. The ability to be able to set aside a decision and send the applicant away knowing that they have been successful.
Well, then why not limit it to cases that where the application is granted?
Well, that's a matter for the department and the attorney.
But, the real concern here is matters where the application is refused and they're unable to see the reasons to challenge it. So from your perspective, Registrar, would limiting this to applications where the application is granted, would that still provide the kind of efficiency outcomes you want?
Yes, it does, because it does still invite the applicant to seek the written reasons if they want them. They may not be going to appeal it,
they may not be able to if they haven't got the reasons, but this is the, can I go to the identity point? I'm sure you've read the concerns about the particularly vulnerable cohorts that this would be impacting. There is almost no detail in the bill about how it's intended to work. Registrar, how have you been told this identity power for, requirement for mandatory dismissal in the absence of verification of identity? How have you been told that is intended to work?
We understand that the applicant will need to present to a tribunal, either in person or virtually, the details of which I'm yet to see, their identity. Now, given that we're dealing with a current caseload, I understand that it's from applications from a particular period in time onwards. It's not the older cases. I'm not sure that we're going to be dealing with people who have no identity papers. There's fewer, if not any, illegal arrivals now.
When you say you're not sure, are you saying that these questions about someone who's stateless, someone who doesn't have identity papers, are you saying that how that would be dealt with, you haven't got an answer to how those would be dealt with?
No, because I don't have the detail yet on what identity documents might be acceptable.
So who's going to produce this detail?
I expect that can be in the regulations.
You expect, but you haven't had, the department hasn't sat down with you and said, well, this is what we're intending to do, these are the obligations, this is how you're going to have to deal with this. None of that's happened? I think Mr. Inverarity identified before that we would be having those discussions. Does the department, I mean, it seems odd that you've produced this legislative requirement on a tribunal and you haven't discussed with the tribunal how it would work. Is this how it normally happens?
Don't think I would comment on how it normally happens, other than this is work that's yet to come. It's going to be in regulations because it needs to be flexible and needs to be able to adapt, and we will be working that through with both the tribunal and the FCFCOA, as I said before. Obviously, we've been focused on supporting the passage of the bill, but we anticipate embarking upon that work very soon.
So for the, Hazara woman who's fled with her children to Australia from Afghanistan, never had a passport, never had travel documents, it's come on shore, the Afghan embassy has shut. She obviously isn't going to go and approach the Taliban in Afghanistan for identity documents, because then her family could well be persecuted and killed. What processes will there be in place for a woman in that situation to have her identity verification assessed and not have a mandatory dismissal of her application?
I suspect I can't give you an answer with the precision that will make you happy, other than that I have referred already to the fact that this is an issue that is already well known to the Australian government. The National Identity Proofing Guidelines cover the need for alternative proofing arrangements for people who do not have the traditional suite of identity documents, and we will be working that through, including, as I mentioned, learning from the experience of the Department of Home Affairs, who do this already as their day-to-day business, so that we build a system that is appropriate and does not punish people like the situation that you have just described. That is not the intention at all, and we will be working to ensure that we have appropriate arrangements.
I think you're right to assume that I wouldn't be satisfied with a decision that says you're going to work to get a solution at the time that you've presented this bill for parliamentary approval. You're correct in assuming I wouldn't be satisfied with that answer.
I note that.
Thanks, Chair.
Thank you, Senator Shoebridge. Senator Cox.
Thank you very much, Chair. And can I start with the Attorney-General's Department? A number of witnesses and submitters today have articulated some concerns about the additional authorisations for registrars. Can the Department please explain what are the registrars currently authorised to do?
Sorry, I think the question was what registrars are currently authorised to do, but I think Mr Hawkins might be better placed to speak to that than the department.
Yep,
so I might
that's
throw
fine.
it to
Thank
him.
you.
Senator, whilst I don't have a comprehensive list, I can give you a number of the authorisations. So Section 19.2, they can extend the period during which an applicant may apply to the tribunal. Section 22(1)(c), decide if it's appropriate that a person who has applied to the tribunal become a party to the proceeding. Section 28, they can shorten the period within which the decision maker must give a statement or a copy of a document to the tribunal. Section 28(6), extend the period within which the decision maker must give a statement or a copy of a document. Section 31(2), consent to the alteration of a decision after an application has been made to the tribunal if the parties to the proceeding for the review consent to the alteration. Section 32(2), make an order staying or otherwise affecting the operation or implementation of the decision if the tribunal considers that it is desirable to do so for the purpose of ensuring the effectiveness of the review. Section 70(1), give directions prohibiting or restricting publication or disclosure of information relating to parties, witnesses or persons. Section 70(2), give directions prohibiting or restricting publication or disclosure of information relating to proceeding in the tribunal. Section 74(4), refuse a request for a person to be summoned. Section 78(1)(b), permit a party to a proceeding to inspect or take a copy of a document or thing produced under a summons in relation to the proceedings. Section 79(1), give directions in relation to the procedure to be followed for a proceeding in the tribunal. Section 80, hold a directions hearing in relation to a proceeding in the tribunal. Section 85(1), remit the decision to the decision maker and ask the decision maker to reconsider the decision in their uncontested cases. Section 96, dismiss an application made to the tribunal where the parties consent, other than by non-participating party to the proceedings. Section 97, dismiss an application for review of a decision where the tribunal is satisfied that the decision is not reviewable by the tribunal, otherwise known as no jurisdiction cases. Section 98, dismiss an application if a fee payable by the applicant is not paid by the time prescribed by the rules. Section 99, dismiss an application if the applicant fails to appear at a tribunal case event. Section 100, dismiss an application if the applicant fails to do either of the things mentioned in A and B within a reasonable time. Section 103, make a decision in accordance with terms of agreement of the parties, that is a decision by consent. Section 103 sub 3, give effect to the terms of the agreement made by the parties without dealing or further dealing with that part or matter of the hearing. Section 103 sub 4, vary or revoke a decision made pursuant to an agreement of the parties in accordance with subsections 2 or 3 mentioned. It can determine the amount of fees or allowances to be paid where the person summoned and the party cannot agree on the amount. That's pursuant to the ART rules. And there's also a power to determine whether an application for a review of a reviewable migration decision or a reviewable protection decision is properly made under sections 347 or 347A.
Thank you, Mr. Hawkins. I don't know if it would be the department or yourself who could answer this question, but are there any safeguards for these current authorisations that exist?
In the case of dismissals, an applicant can seek reinstatement of their matter.
Great,
and all decisions of registrars are subject to appeal.
Excellent, thank you. Are there any other entities within the justice system that allows registrars to exercise similar functions, specifically to dismiss where there are no reasonable prospects of success?
I'm just looking down at my colleagues. Obviously, registrars also exercise functions in the federal courts. Mr. Adams, did you? Thank you.
Yes, I can talk to that. As Ms. Inverarity has said, registrars do exercise a number of the judicial functions conferred on courts. Consistent with the Constitution, those functions are under the supervision and oversight of the judges. So it is the judges who choose what can and can't be delegated either on a case-by-case matter or as part of the rules. And any exercise of judicial power by a registrar is reviewable by a judicial officer as of right.
Great, thank you very much for that. I do want to move on to the delivery of and the issue around oral reasons. Again, some submitters and witnesses that have appeared before this committee have articulated concerns with the proposed changes to the delivery of reasons orally rather than always in writing. I've noticed that these decisions and reasons have occasionally been used interchangeably. So I'd be really grateful, and I'm sure other members of this committee would be, if the department could give us clear and concise articulation of what those proposed changes actually are.
Thank you, Senator. I think Mr Hawkins earlier nicely summarised the distinction between a decision and the reasons. I'll very briefly summarise and then I'll see if he wants to add anything further. The position in line with the bill will be that a written record of the decision itself will always be provided and will be required to be provided. What the bill will introduce is a discretion to allow members to provide reasons for that decision orally. And if oral reasons are delivered, then the applicant could request those reasons to be provided in writing. But Mr Hawkins, you might wish to add to that?
No, I think you've summarised it very well.
Excellent, thank you. So the changes we are examining relate specifically to the reasons. So for the avoidance of doubt, if an applicant still wants to receive a written decision at the end of this matter, I just want to confirm that it can be delivered in writing. Is that correct?
The decision will always be in writing. There will be cases where the reasons are also given in writing. There will be cases where the reasons are given orally and either party has the right to request those reasons to be provided in writing, but the decision will always be provided in writing. Great,
thank you very much. And I know that, just for the record, a number of submitters have talked or made reference to written reasons, the importance of that in relation to transparency and improving government decision making. So those safeguards obviously exist for applicants and respondents who still want those written reasons. That's correct, is it?
Correct. And if an applicant or either party requests reasons, the tribunal must provide them and must provide them within a fixed time frame. So that's an obligation that would apply to the tribunal.
Great, thank you.
I think it's important to emphasise that reasons will always be made. Right? We're not getting away from not providing reasons.
Yeah, great. Thank you for clarifying that, Mr Hawkins. I just also have some questions around the identity verification requirements. So could the department briefly explain the identity verification proposals to this committee?
Sure. So the bill would amend the primary legislation to provide a regulation making power which would outline identity verification requirements for certain cohorts of decisions. Those would be certain migration and protection decisions. The regulations would specify who is subject to those identity verification requirements and when an applicant is not or ceases to be subject to those requirements, how the applicant must satisfy the requirements, how the tribunal must give a written notice to an applicant that states they are subject to those requirements and how they are to satisfy it, the circumstances in which the tribunal may reschedule a requirement to attend, such as the time, place or manner of attendance, to be able to satisfy those requirements, and how the identity verification requirements interacts with certain provisions in the ART Act and the Migration Act.
And it's worth noting we've focused a lot on identity verification in the tribunal, but the process will also apply in the Federal Circuit and Family Court in a similar but slightly different way. I might see if colleagues want to very briefly describe how it will apply in the court.
Thank you. I can talk to that. So similarly as Ms Vittoria has articulated, the bill would provide a regulation making power very similar in relation to prescribed judicial review of prescribed migration decisions in the Federal Circuit and Family Court of Australia Division 2. Those regulation-making powers, like in relation to the tribunal, include who is subject to the requirement and when they are not or cease to be subject to the requirement, how they may satisfy the requirement, the requirements for the court to give a notice to the applicant that they are subject to that requirement, circumstances around rescheduling, and how the identity verification requirement interacts with provisions of the FCFCOA Act and other provisions of the Migration Act. Because of the nature of the FCFCOA as a court established under Chapter 3 of the Constitution, there will also be additional discretion that the court must have. And so considering that, the regulation-making powers in relation to the court will also allow for requirements to be set out relating to the procedure and consideration for the court to exercise its power to dispense with the requirement. Matters relating to how the court is to exercise its jurisdiction under the Migration Act in relation to an applicant subject to the requirement, and other consequences which may arise if an applicant fails to comply with the requirement.
Great, thank you for outlining that, a really important point. I know that I come from a very large jurisdiction in Western Australia, and there's people who are spread over vast distances. So it can be difficult for some people to actually physically present themselves to a registry to verify their identity, particularly people from regional and rural communities. Does this bill make any accommodations for individuals who are in those circumstances?
There is no doubt that online identity verification will be a feature of the arrangements going forward, both to support people like who you've described in rural and regional areas, but also to ensure the efficiency of the arrangements for all parties. So although the precise details haven't been worked out, we can say with absolute certainty that online identity verification will need to be a key feature as this is developed, designed and implemented.
Great. And obviously circumstances are a large part of that, and events can happen at short notice, which obviously impact on the lives of applicants. Are there any safeguards included in this bill that cover some of those instances?
Yes, certainly. So as I mentioned, the regulations would specify an ability for rescheduling if there was a circumstance where an applicant would need to reschedule for a certain reason. There's also the consequence, I guess, is of. Sorry, I'll start again. The consequence of an applicant not complying with these identity verification requirements would be that the tribunal would dismiss the application. However, before that can occur, the applicant would be provided in writing notice of that.
Great, excellent, thank you. And just my last question, if I can, I note that there are a number of submitters that have commented on the no legal funding to assist people in the judicial review stage when they're expressing their reservations about this proposal. Is that correct? And, would appreciate, some understanding of what that might look like, but also has this been raised with the department before?
Sorry, this is legal assistance, did you say?
Yes, that's right.
Yeah.
The no legal funding, yeah.
We've noted those concerns that have been raised. Obviously, last year the new National Access to Justice Partnership commenced, which is a national agreement through which the Australian Government funds frontline legal assistance services, and under that partnership the Australian Government committed $3.9 billion over 5 years to legal assistance, including $800 million in new funding. State and territory governments are responsible for allocating that funding to legal assistance providers. But also worth mentioning, given the focus on migration-related decisions, that partnership also specifically focuses on culturally and linguistically diverse people and vulnerable migrants, including refugees and asylum seekers, as priority clients. seeking to ensure that their legal needs receive specific consideration in both planning, funding and delivering legal assistance arrangements. We're happy to provide further detail on notice if that would assist.
That's great. In the interest of timing, I'll take that offer up. And that's it from me, Chair. Thank you.
Thank you very much. Well, that concludes today's proceedings. The committee has agreed that answers to questions on notice taken at this hearing should be returned by COB on the 30th of July. I note that's only 3 days from now, but we've asked for that deadline as the committee is required to table its report on the 7th of August. Thank you very much for your time this afternoon and to all witnesses who have given evidence to the committee today. Thanks to broadcasting and to the Secretariat managing the tech difficulties of the day. And thank you also for appearing a little ahead of schedule from when you were supposed to be on the program too. So appreciate your assistance for the committee. I declare the hearing adjourned.